court and the public defender's office. Although the people do not believe there is any conflict, will make this waiver for.
Good morning, Your Honor. Your Honor, we too do not believe that there is a conflict, but would waive any conflict in case there is any doubt.
That's cute. The court, for its part, also does not believe it's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Angelina Bonacera.
Ashley Feltus for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Serps on behalf of Ms. Bonacera. Can you please state your name for the judge?
Bonacera?
Your Honor, we'd just be requesting an adjournment so we can coordinate a visit with Ms. Bonacera.
Like ages.
I know. Good. How are you, Your Honor?
Doing okay. So go up here and then you ask for an adjournment. All right.
That a lot this morning.
How much time did you need?
Your Honor, a few weeks.
My dates are all off here. You go 6 and 13.
Correct.
Probable cause conference, we're gonna have to go to the 13th. She's in. Probable cause conference will be adjourned to August 13, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Ew.
Thank you.
Court calls the cases of the People versus Chad Jones.
Ashley Feltus for the people in all matters.
All 6 cases. Oh,
Good morning, Your Honor. Alexander Hermanowski on behalf of Chad Jones, standing in for Ed Drukas on a case ending in 2196.
Mr. Lebo's on there.
we're all looking for Lebo.
Oh, easy. What's up there? No, this is no turn.
You should close on these. Somebody go get him.
He is in both courtrooms. He did say he put his notes in the files, we're just gonna pull them up.
Okay. I'll wait.
So sorry. I just love it.
No, you're the only one that could get away with this. So, Mr. President, how are things going?
Fantastic.
All right.
Things couldn't be better.
Well. We're off to a rip-roaring start. Mr. Jones, can you state your name, please?
Chad Jones.
Thank you, sir.
Your Honor, in terms of a case ending in 2196, Mr. Jones is waiving his preliminary examination.
2196, he's waving on now.
Yes, Your Honor.
Sorry. Mr. Jones, is that correct? You're waiving your right to a preliminary examination in that case?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
You'll also waive their right on that case.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Hermanowski. Waive formal.
Yes, Your Honor.
Line stand.
Stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in that case will be set for
August 17th at 1:30 with Judge Hamoud.
August 17, 2026, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you.
Your Honor, could,
Bond will continue with next.
so sorry.
Go ahead.
Your Honor, could we pass on this for just one moment, please?
I don't know how long MDOC is gonna wait.
I will not be long.
All right. Mr. Jones, I'm gonna pass your other matters and then get your call back up momentarily, okay, sir?
All right.
Court calls case People versus City Hall.
That's both people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Hall.
Yes,
State your name.
Sade Renee Hall.
All right. And what are we doing?
Your Honor, this is a time and date for a competency hearing. I did meet with Ms. Hall yesterday and went over the competency evaluation with her. We don't have any additions or corrections to that report. We don't have anything.
What's the date of your report?
I cannot hear people acting out right now, and they got the camera on me, and I'm looking at myself, and I look darker than what I appear. Like,
Okay.
this is messing with me.
Okay.
Put me as like I'm.
Oh, just hold on a moment.
I mean, I'm very light skinned.
What was the finding on that?
I have July 17th with the finding of incompetent but restorable, I believe.
Yes, it says the possibility of restoration, Your Honor. It was, July 17th, we received on that.
Okay, I see.
This is
All
messing
right.
with me. Look at
Court
my,
will find that at this time is incompetent to stand trial, but restorable. Court will sign the order to that effect. I'll set a competency review hearing
see, the color is just fading.
9th, 2026, 9 AM.
Thank you, Your Honor.
Thanks.
I can't hear. She's messing with the screen now.
you. I'm sorry, ma'am.
Ash is messing with the screen. She put it on unmute.
Okay, we're all done. We'll see you
I
in
didn't hear what
October.
happened.
What happened? I made a finding based upon the report. And then I set a review hearing for October 29th. And we'll see you then.
Ninth, my birthday is on the 18th. I've been here since April 16th.
Okay. We'll see you then. Thank you.
Call is ready.
Court does call the case People versus Joseph Lovely.
Assistant Public Defender Zach Binu with and on behalf of Mr. Lovely, who approaches. Sir, can you please state your name?
Joseph Lovely.
Your Honor, we're requesting an adjournment. Mr. Lovely is waiting on a bed for treatment, so we are requesting adjournment for that purpose.
This is the only thing holding him?
I believe so, yes.
All right. How much time did you want to give him?
3 weeks should be enough, Your Honor.
Public cause conference will be adjourned August 13th, 2026, 9 AM. Bond continued.
Thank you, Your Honor.
Thank you. Court recalls the cases of the People versus Chad Jones. There remains 5 matters.
And Assistant Public Defender Nicholas Vukovich on behalf of Mr. Chad Jones in all matters.
Jones, can you state your name again for me, sir?
Chad Jones.
Thank you.
Yes, Your Honor, at the time, we'll be setting all his matters for preliminary exam. To my knowledge, all discovery is complete.
All right. Yeah. Oh. All right. People have their witnesses available. Date, what date? People have their witnesses available August. It can't be August 1. Normally we'd be on the 30th. It's not going to be August 11th.
We'll try for that date, Your Honor.
Preliminary examination in person, August 11th, 2026, 9 AM, but we've got to transport him. What facility are you in, sir?
STF, St. Louis.
We're going to have to give more time than that.
I forgot he was in the state.
Set it for August 18th, 2026, 9 AM before Judge for me on the 18th. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Jones.
Thank you.
Court does call the case, People versus James Johnson, 2 cases.
Good morning, Your Honor. May it please court Lowell Friedman, P 5625. Your Honor, I appear on behalf of Mr. Johnson for one of his 2 cases. Specifically, that's case number 26 FB 1411-FY.
Chelsea Vergils with and on behalf of James Johnson on the other case. Please state your name.
James Johnson. Thank you.
Your Honor, as to the first case, I'm in receipt of discovery as of last evening, but I haven't had a chance to review it, make sure it's comprehensive, nor have I had a chance to provide it to my client. My client understands his right to have the 21 days probable cause examination, wishes to waive that to return back to Your Honor. I looked at my calendar, Judge. There's only one Thursday that I have coming up that I'm triple booked, and that would be the 13th of August. Any other Thursday would be.
Asking for an adjournment.
Yes, please.
Do you want to have your cases together and have the preliminary exam for my case the same day as work, or do you want to set basic
Public Defender Office.
for the controlled substance? I would ask to adjourn as well to keep along with his case.
The next probable cause conference will be adjourned in both matters to August 20th, 2026, 9 a.m.
Thank you, Your Honor.
On continue.
Thank you very much, Your Honor. Have a good morning.
Court does call the case of People versus Rashad Barron. Excuse me.
I don't know.
Good morning, Your Honor. Marcia Patron, on behalf of Mr. Bearden, who's approaching. Mr. Bearden, can you please state your name for the court?
Rashad Beard. Thank you.
Your Honor, if I may briefly, we are requesting to go to a preliminary exam at this time. I've spoken to Madam Prosecutor in this case. The pieces I'm missing is some media that she says should be get today, but in reviewing the police report, it's actually going to be eyewitness testimony. There is no video that relates to the crime of this. Therefore, I'm not sure how helpful.
I don't know what all that means.
Discovery is not complete, Your Honor. The media that I'm looking for isn't relevant to its eyewitness testimony would be an exam regarding the crime.
And Your Honor, I believe Ms. Frazier was appointed yesterday. That agent was sent to the public defender's office, so it should get over to Ms. Frazier before it's fully work.
Excuse me. And also, it's Mr. Bearden, I was informed that there's a parole hold, and this is the only thing that's holding him, Your Honor. So we'd ask to go to exam as quickly as possible. Well,
Hey, Your Honor, can I say something?
I don't know if it's wise for you to do that, but if you want to say something, you can go ahead.
I was already going to court for this when I was just free in the world. I had a Zoom court date. I don't know why they ain't uplift the warrant for me, but I was already going to court for this in the world. I'm on a tether. I got a job. It ain't like I'm running from this case or nothing.
it made that argument because agent body or can't look at.
And Your Honor, I have this case being arraigned on 7/19, and he does have a hold permit against the 2009 for violating school.
Got it. Okay. Preliminary examination in person will be set for August 11th. Will people have their witnesses available that day?
In because of the pool.
August 11th, 2026, 9 a.m. Judge Barr.
That's the argument.
On
Thank you, Your Honor.
here.
Yes, this is a parole hold.
Court calls case People versus Kenyatta Johnson.
Can I spell this for the-
Well, Your Honor, Christina Saxon, Judge Johnson. Excuse me.
State your name.
Kenyatta Johnson.
All right, what are we doing?
You're on arrest for an adjournment. Prosecution is still waiting on delivery of discovery that hopefully will be here within next week, so.
Preliminary examination will be adjourned to August 20th, 2026, 9 a.m. Bond continued.
I'm sorry, Your Honor, I didn't hear the date.
August 20th,
20th?
0.
Okay. Your Honor, I will not be in the,
I'm sorry?
I will not be in the country on the 20th.
Won't be in the country? Good. Okay. You know, every time I have to work around like your schedule, you just are jetting around the world. So what date will you be here on a Thursday? Hold on, Miss Johnson, we'll get it together.
The following Thursday.
The following Thursday? All right, let's make it August 27th, 2026, 9 a.m.
It'll be my last in 4 years.
That'll be your last vacation?
4 years.
I don't know why. I did just say it out loud. All right, thank you.
Thanks.
And continue. Thank you, Ms. Johnson.
Thank you.
Court does call the case. People versus Phoenix Forms.
Asphalt people.
Good morning, Tina Saxon for Phoenix Forms.
Your name? Phoenix Forms. You're requesting an adjournment of this?
Yes, Your Honor.
Want the bond violation also adjourned?
Please. And if I may make a bond argument.
Okay. I will adjourn this to August 6th, 2026, 9 a.m. Yes, as the bond.
Your Honor, I'm asking for a release on house arrest for this matter. The reports I'm waiting on deal with mental health, and having him out would be much easier to address these matters than having him incarcerated. And with house arrest, I believe it would still meet the objectives of both the court and defense.
Bonds.
I apologize, Your Honor. I couldn't hear everything that Ms. Saxon said. However, it is my understanding the defendant on this case was originally released on a home confinement tether. He violated his home confinement tether and then eventually was able to be re-released, and now is up a week from today on a new case involving a stolen motor vehicle. So I do not believe he is a good candidate to be released.
Your Honor, if I just may remind the court that the violation when he was on house arrest was over an issue of his mother demanding that he leave. Once we explain that to the honorable court, that bond violation was released. And
But he's got a new case coming up.
yes, I just wanted to say that he didn't just wantonly violate that bond while he was on house arrest. He was compliant other than that incident that we justified.
Motion for bond reduction tonight.
Thank you, Your Honor.
Thank you. Court does call the case People versus Daniel Polgar.
Albert, on behalf of Mr. Polgar, who's approaching the podium, will be standing to my right.
Your name?
Daniel Polgar.
You're waiving?
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes, Judge.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Judge.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further proceedings?
Yes, Judge.
People also waive their right. Preliminary examination have been waived. Defendants bound over to circuit court on both counts.
And Your Honor, there is an offer, if I may place it on the record.
Go ahead.
Your Honor, so the people at this, in exchange for the waiver, the people are offering to plead to HIDA at circuit court as charged, no upfront jail, three years probation, and no early discharge.
Both counts?
Yes, Judge. It's my understanding.
It's not a conditional waiver though, since something changes upstairs, we're not doing that.
Understood?
Understood.
As to the arraignment,
Stand mute, waive formal reading.
defendant have away from a reading, standing mute. Court will enter not guilty plea to both charges. Pretrial will be set for
September 22nd at 1:30 with Judge Cumby.
September 22nd, 2026, 1:30. Bond will continue.
Judge. Yeah, Judge.
Court does call the case People versus Tommy Butler.
Ashley Feltus with people.
Morning, Your Honor. Sam Bernstein, Whitson, on behalf of Mr. Butler. Butler, could you please state your name for the court?
Tommy Butler. Thank you.
We're asking the court to please set this for preliminary examination. Discovery is complete.
Right, it's just the only thing holding him.
This remote fell and one of the batteries fell out. It was like,
Thank you. People have their witnesses available the 4th. It's 1 week out. We're
No, Your Honor.
not. Okay, the 11th,
Charge not available on that date.
the 11th,
No, Your Honor, you can be available the following week.
the 18th.
Yes, Your Honor.
This is the only thing holding him.
I would ask the court to please have it sooner than the 18th. I understand there's a lot of availability from the OIC, but that's 3 weeks from.
Joe, I see the only witness in the case.
No, Your Honor, we can shoot for this date.
There'll be other witnesses. It may be continued, but I can at least start his preliminary exam.
I would hope so, Your Honor. Yes.
All right, so what I'm gonna do is I'm gonna set it for August 4th, 2026 at 9 AM before Judge Perry.
Thank you, Your Honor.
Fine, continue. Thank you. Court calls case People versus Sugat Hampton.
Ashley Feltus with people.
Chelsea Rickmeals with and on behalf of Suzette Hampton, please state your name.
Suzette Hampton.
Your Honor, we are asking for an adjournment in this case for some additional media discovery.
For media discovery.
Yes, Your Honor.
No objection, probable cause conference will be adjourned August 13th, 2020. Bond continues.
Your Honor, may I address bond briefly? Ms. Hampton would.
No.
She is, Your Honor. It's a condition of her release to not leave the state of Michigan. She just informed me that she needs to drop her granddaughter off in Ohio tomorrow morning. And
Purpose?
unfortunately,
I don't know why people go to Ohio. Go ahead.
sometimes we have to, Your Honor. I believe it would be a brief trip just for the day. Where specifically are you going?
I'm going to Wilberforce in
Where?
Ohio. Wilberforce College in Ohio and Zeke, Ohio.
Dropping
My last granddaughter off.
you're dropping your last granddaughter off
That I raised.
for us.
Yes, sir.
Start
Tomorrow
school.
morning. Yes, to start college.
I don't even know how I stand in the way of that.
I appreciate it so much.
When are you taking her down?
We'll leave it in the morning at 5:30 a.m.
Tomorrow morning?
Yes, sir.
So if I said no, what would happen?
I would have to find transportation for her to go to college.
Not even, I don't need. Is there any objection from the?
No.
I'll indicate that defendant may travel to Ohio. What dates do you plan? You're going tomorrow, so that's the 20.
I'm returning back tomorrow.
Just one day?
Yes, sir. Drop her off, decorate a dorm and all of that.
Come back the same day?
Yes, sir.
You don't want to be in Ohio for too long, right?
No.
Wow. Oh, Chelsea. Stole my line. All right. Yes, ma'am. You may travel to Ohio on July 29th.
Thank you so much.
2026.
I appreciate it.
All right. Not a problem whatsoever. And congratulations to your granddaughter.
Thank you.
Your Honor.
Court does call the case. People versus Kevin Sherrari Lowry.
Feltus with people.
Oh, no, I'm sorry.
No, he's here. No.
Good morning, Your Honor. Bernstein with and on behalf of Mr. Shenovar Lowry.
Your name?
Kevin Williams, Shenovar, Lowry Jr.
Thank you.
Your Honor, I'm hoping for an adjournment. I'm hoping to work on a resolution before we get to the exam stage.
All right. 13th meeting,
Yes, Your Honor.
probable cause conference will be adjourned August 13th, 2025. You can see me. Bond can.
Your Honor.
Court calls the case, People versus Warren Abbott.
Can I get a muted?
Have developments with people.
Good morning, Your Honor. Karma Dadush on behalf of Mr. Abbott. Mr. Abbott, can you please state your name for the record?
Warren Abbott.
Thank you.
All right, go ahead.
Your Honor, we have received the competency report that was sent by the Forensic Center with regards to Mr. Abbott. We have no additional information to support or contest the finding and would ask the court to find him competent and ask to set the matter for PCC.
Any other evidence?
So if you want no additional evidence, you all can put the report and ask the court into that finding.
Court, after review of the report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist defense. Therefore, the defendant is deemed competent. Do you have an order, counsel, or no?
I will prepare one.
Why is that a surprise?
It should be.
Asked if you had an order.
It should be a surprise. I'll submit one. Yes, Your Honor.
Right. I'll set a probable cause conference for August 6th.
Can I address bond, Your Honor?
Man,
Is this a good time? Is Your Honor ready?
I'm ready always.
I was going to be asking for Mr. Abbott to be released on his own personal recognizance. He has been held for some time pending this competency. He does have a place to stay, his own place. He also has his adoptive mother that he can be, released, a good member in the community to help bring him back to court. He did have a job, but he is hoping to get a job when he gets out. So we'd be asking Your Honor for that. He is willing to put on any tether to ensure. I don't believe he's a flight risk, and for that reason, we'd ask for him to be released.
The facts of this case are very disturbing. The defendant unlawfully entered the victim's home. She was asleep and woke up to find him standing over her / on top of her. She screamed, covered her mouth. There was a struggle. Camera did catch him nearby leaving her house or in the parking lot immediately adjacent, wearing certain distinctive clothing items. So the people were very concerned, and we did ask for a high cash bond when the case was initially brought, and we maintained that request.
Motion for bond reductions denied. Bond will continue.
Thanks, Your Honor. We'll come talk to you at the jail, Mr. Abbott, okay?
Court does call the case. Court calls the case, People versus Timothy Lacey.
People.
Good morning, Your Honor. Assistant Public Defender Daffy Leba on behalf of Mr. Lacey.
Good morning, Your Honor. Timothy Lacey.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination. Please, discovery is complete.
Counsel approach. before Judge Garwood.
Thank you, Your Honor.
On continue, court calls case People versus Floyd McMurray. And
People.
On behalf of Mr. McMurray, standing in returning of record Bill Amadeo. Mr. McMurray, please take a name for the record.
Floyd L. McMurray Jr.
I thank you, Your Honor. Today's date and time set for probable cause conference. Mr. Amadeo was just appointed, so we are asking for a brief adjournment.
probable cause conference will be adjourned to August 13, 2026, 9
Thank you.
Thanks.
Thank you.
Who's on there? Program. Just myself. Okay. You could run it to, sure. Or this case of the People versus Travaris Durham. Two cases.
Kenneth Elvis for the People.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Durham.
Your name?
Tavares Durham.
All right.
Your Honor, we're asking the court to please set this for preliminary examination. Discovery is complete. And if I could address bond at the appropriate time.
People have their witnesses available the 4th.
You try for that date, Your Honor.
Our preliminary examination, both matters will be set August 4th, 2026, 9 a.m. before Judge Washington. As to bond.
As to bond, it's going to be very upfront with the court. Mr. Durham.
Thank you.
Yeah. I guess it'll sound slightly better for me than Ms. Feltus. Mr. Durham did fail to appear at a preliminary examination 3 years ago. We are here now. He is very sorry that he did not appear. He was a bit more unstable back then, and he has done a lot in his life since then to gain some security and stability. He has an apartment now.
3 years ago?
Approximately.
I just wanted to make sure.
2023, Your Honor, yeah.
Okay, all right, go ahead.
But he has really worked hard in the interim. He has an apartment now, he's housed, he has rent due on August 5th. He has a 1-year-old son who is now with his mother while he's been incarcerated, but he's eager to get back with him. He has a job now with Miles and Sons Landscaping that he can return to if released. And I would suggest that all of his strides that he has made
into custody.
He was in a car that was pulled over by the police.
Oh.
It wasn't a new charge, at least, right? So the car was pulled over by the police and he was a passenger. And when they looked him up, they saw who he was.
And then he came into custody 3 years later.
And we're begging the court's consideration for any sort of bond reduction that may be possible.
Oh, yep, she popped right up. Go ahead.
For the court stated 2 cases. One is an armed robbery where bond could absolutely be properly denied and should be, in my opinion. I will let the court know that 3 years ago, when the chief was proceeding to preliminary examination, he had good contact with the victim who was on their way to appear when the bench warrant was issued for the defendant. So I do believe that bond should properly be denied.
Motion for bond reduction is denied. Bond will continue as denied. Thank you.
Yes. Thank you for your consideration, Your Honor.
Yeah.
I just put shoe bar.
Did you?
Yeah, court does call the case. People versus Aaliyah Benton.
Good morning, Your Honor. James Letfelski appearing on behalf of Aaliyah Benton Rochen. If you can, please.
Aaliyah Benton.
Thank you.
Your Honor, we're asking for an adjournment. The holdup is there's a co-defendant who is in custody, I believe in Georgia, and he's in an Arkansas. He's in an extradition process, and we can't really do anything until he gets up here. So we're kind of at a standstill, but.
That's correct statement. We're working on it. extradition process for that codependent family. His
Right.
presence will be very hard to have a resolution in this case.
I'll adjourn it at this point to August 27, 2026, 9 a.m. We can figure out where we are at that point.
Okay.
All right, Bond, we'll continue. Thank you.
Thank you. And just one comment, Ms. Spring, and I believe we have a stipulation to modify the no contact order with regard to Samir, the youngest child, because DHHS has been supervised parenting with my client and her other kids. And I believe we're in agreement that as long as it's supervised.
Thank you.
Your Honor, we are going to waive preliminary examination.
Right. Sir, is that correct?
Yeah.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, but you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following.
We'll stand mute, Your Honor, waive formal reading of the charges.
Defendant have waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
August 10th at 1:30 with Judge McNally.
August 10th, you said?
Yes.
August 10th, 2026, 1:30, Judge Hamoud.
Can I address bond, Your Honor?
Why not? Everybody else. Go ahead.
You remember, he couldn't stop using and we had to get him someplace safe. He went in the hospital to detox and he was there for a week. As soon as he got out of the hospital, you had told him to report to the jail immediately, which he did on the 15th of July. And he reported right from the hospital to jail. He's been there ever since the 15th. I just got notice this morning that he is eligible for felony treatment court. They would like to do a screening and assessment as soon as possible. So I'm hoping that I can get him released back to his father's house and to get him continue in recovery. He's done everything that the court wanted him to do, obviously in a scram tether with testing requirements, but I think it's a really good what you did here to allow him to safely detox because he has seizures and he's been injured before from the seizures. So when he was in the hospital, he went through the seizure protocol and got through that. And he's been in the jail now since I'm hoping that you allow him to go back home and we can get him into felony treatment court.
Your response to the people.
Yeah, I still have a lot of the concerns I had the last time. I just want to place on the record. This is an OWI third. Priors are from 2016 and 2024. In this case, the alleged offense is that he was operating under the influence of fentanyl, methamphetamine, and THC. He did have some very concerning initial positive tests. More concerning, maybe even so, is that he stopped showing up to community corrections and then the warrants got issued and everything that Mr. Shan just placed on the record happened. I'm very optimistic about felony treatment court for this defendant, but the concerns I have for bond right now are just the not showing up, kind of going up. I'm just worried about his ability to keep the public safe and how much the public safety does depend on that at this point, but I leave it as a court's discretion.
When is his assessment?
Courtney said as soon as tomorrow that
he may do that tomorrow.
Tomorrow, yes.
Okay.
Now that I'm clean, I have full intention of showing up to community corrections. I just kind of.
Hey, you know what? Hey, young man, I'm not mad at you. Okay. I'm mad at the drug that you're hooked on.
I saw him yesterday. I said, "I've known him for a long time. This is the best he's looked in a long time."
I remember when you were.
I'm on the program now, and I don't know, I'm giving it my best effort.
Yeah, no, I got you. So who would have his felony?
It'd be it would probably be Judge Carol Cookie because she's doing most of the felony. This is a felony drunk driving. However, his drugs of choice are all are non-alcohol related.
Okay.
So it's meth and Xanax, methamphetamine. Well, it's easier to list the drugs that he's not taking than it is the drugs that he is taking. So I think he'd be a perfect fit for Judge Cookie's felony treatment court. And I've already let Judge Hamoud's staff know that he's coming. So hopefully we'll have everything lined up for a smooth process and get him in treatment court as possible.
Okay. Here's what I'm going to do. And understand, I'm not doing this to punish you, young man. I'm worried about you. Okay. And I think you have full intentions of doing what I say, but I'm just worried about it. I'm going to deny the request for a change in bond at this time. However, I'm specifically placing on the order that I have no objection to his release after he's assessed by drug court.
Perfect.
All right.
Perfect. That's all I was. Thank you, Your Honor.
At this time, his bond will continue. All right. Thank you. Good luck, Chief.
I'll report the motion. Probably be here.
Court calls the case People versus Michelle Schaffner.
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Ms. Schaffner. Michelle, can you please unmute and state your name for the court?
Michelle Schaffner.
I need you to turn the camera on, please, ma'am.
Sorry, I'm at work.
Okay. I've seen people at work before. You're good. All right. What are we doing?
Your Honor, Ms. Schaffner's co-defendant was Kenyatta Johnson, whose case this court heard a little bit earlier this morning. That matter was adjourned to August 27th due to some outstanding discovery. It's my understanding that same outstanding discovery is missing in our case. So we would be asking for an adjournment of the PCC for that same reason.
Correct, Your Honor.
I'll adjourn the matter August 27, 2026, 9 a.m. Bond continued. Thank you.
Thank you very much, Your Honor. Have a good rest of your day.
You do the same.
Thanks.
Pardon? Court does call the case People versus Raymond McCarthy.
People.
Alexander Hermanowski with and on behalf of Ramon McCarthy for the case ending in 5144.
And Ken Madadush on behalf of Mr. McCarthy in the other matter. Can you please state your name for the record?
John Andre McCarthy.
All right. Go ahead. What are we doing?
Your Honor, with regards to 5144, this matter being adjourned, requesting that it be adjourned as Mr. Drukis, who I'm standing in for, just was appointed on the matter yesterday. So we're asking both the bond violation and the PCC be adjourned.
And we were going to be asking for an adjournment on the 5146 matter. I believe there may be a potential case that may be getting authorized. So we'd ask for an adjournment on all the matters so we can resolve them globally together.
There's another case being authorized. Do we know anything about that?
There's another potential misdemeanor.
Oh, misdemeanor.
It may end up being a felony. I haven't had a chance to review it, Your Honor.
Okay. Are these the only things holding him, or is he held on something else?
I'm checking, Your Honor, but I believe they're the only things holding him.
And Mr. Drukis just got into the case. I'll adjourn these matters to August 13th, 2026, 9 a.m.
These are the only things holding him here. There are 3 out-of-town holds.
Got it. Okay.
August 13th.
Yes. Thank you, sir.
Thank you, Your Honor.
Thanks.
Court does call the case People versus Dontrell Smith.
People.
Michael Gay, public defender on behalf of Your Honor.
I'm here.
Kind this is the date and time for a competency review. I was unable to see Mr. Smith.
You were not it, true.
No, we were, no, and he was, we tried again this morning and he was not.
He's in. Mr. Smith, can you state your name for me?
Dontrell Smith.
Thank you. All right. So why don't I do this then? I'll adjourn the competency hearing out. You'll be able to get down there by the 4th, or you need,
Yeah, yes, it's just,
I mean, not the 4th,
better,
but the,
based on the previous look, it may be better for me to arrange a Zoom meeting.
competency hearing will be adjourned then to August 6th, 2026, 9.
Thank you.
Bond continue. Hi. Did you see it? You did? You didn't warn me. My cat does that and sneaks in front of me. Put a bell around it. Get a bell. Court calls the case Bill versus Borough Shelton.
Morning, Your Honor. Dan Garrett on behalf of Mr. Shelton. State your name, sir.
Ross Hilton.
Your Honor, asking for an exam day. Discovery is complete. Fortunately, the only day I can't do is the 11th.
You know what? He was free and available up to size.
Yeah,
And
true. Blame Roland.
people have their witnesses available the 18th. Preliminary examination in this matter will be set August 18th, 2026, 9 a.m. for Judge Moore. Bond can
Thank you, Your Honor.
Thank you. Court calls case People versus Michael McLean. 3 cases.
Good morning, Your Honor. Assistant Public Defender Alexis on behalf of Mr. McLean on cases in 5530 and 1395.
Good morning, Your Honor. Christina Saxon for Michael McLean on case 5221.
Your name?
Michael McLaren.
Thank you.
Your Honor, with respect to my 2 cases, we're going to be requesting they be set for preliminary examination.
Same, Your Honor.
All right. Discovery is complete on all your matters.
My knowledge, Your Honor.
Is this the only thing holding him? People have their witnesses available the 4th. All right. Preliminary examination in these matters will be set August 4th, 2026, 9 a.m. before Judge Perry.
And Your Honor, can I briefly address the matter of bond? I would just be asking that he be allowed to be released to treatment.
If you submit unless there's an objection.
Judge, he was
Of course you are.
about 2 new cases and that's now back before Your Honor, so I don't believe that at this time that's appropriate.
So I had previously released him to treatment on one of these
2 more cases while he was out, did not go there,
and didn't go to treatment.
did everyone, and then he picked up 2 more cases and came back to her. So I'm going to object to this. And Your Honor, if it might be a more appropriate time to make that request of preliminary examination, that's understood.
And certainly not appropriate today. I'm not going to sign that order.
Understood, Your Honor. Thank you, Your Honor.
Court does call the case People versus Douglas Hill. 2 cases.
That's all people.
No, take your time.
Miller, P58 on behalf of Mr. Hill. And Michael Gaddy, on behalf of Mr. Hill on 26 FB 1360.
Your Honor, if the court could pass the matter, I've been in
Why would I?
contact with Mr. Hill. He was on the number 4 bus and I expected him to be here by now. If we could just pass it 10.
I don't even know where the number 4. What number 4 bus?
The number 4 runs up and down Washtenaw, Your Honor. I take it from this court when I go down to the circuit court.
Is that right? Okay. Fine, I'll pass it.
Thank you, Your Honor.
See, and I asked him and he couldn't even give me an answer. Did you see how he is? Watch him closely. Did you know the number for him? No? You guys are doing me no good. Court does call the case, People versus Matthew Moy. Your name?
Name, sir?
Oh, Matthew Thomas Moy.
Good morning, Your Honor. Marcia Page on behalf of Mr. Moy. Your Honor, we have two asks today. First is to adjourn the PCC for obtain discovery and further plea negotiations. And the second ask is we would ask the court to entertain a bond reduction motion.
Go ahead.
Okay. My understanding that Mr. Moy has nothing else holding him. He has a current job at Kentucky Fried Chicken. He needs to get back to his job. He also has some apartment that he needs to make sure that the rent is paid. Currently, his bond is $1,000 cash surety. We'll be asking for a personal recognizance bond. This is resisting obstructing. It's my understanding that there was no injuries to the officer. It was basically a running from the police situation. So we'd ask for a PR bond, Your Honor.
Respond.
And my understanding is that the defendant's been on probation in circuit court for carrying concealed weapon and possession of controlled substance for quite some time. There was violation of probation resolved in May 2026 when he had completed treatment. He also has an assault and battery pending while he's on probation. In this case, was pulled over, asked if he could swap away from traffic stop, and the police officer told him no because he had active warrants. He then ran. So I have no faith that he will come back.
What? He explains to me that he will come back, Your Honor. Mr. Moy.
Matter of court.
Go ahead.
Your Honor, this incident was about 5 months ago.
I'm gonna ask you not to talk about the incident.
Okay,
So
I'm just okay. I won't discuss the incident. I was released so I could go to treatment. I've been keeping up with probation. I'm in the courthouse every week, Your Honor. And I've been keeping up with my appointments. The KFC that I work for is right across the street. I've been dealing with the court system for a while, Your Honor, and I understand that I have to take care of these things. I'm not going anywhere. It's not an
Why
apartment.
didn't you come back though?
Why did I come back?
Have all these warrants and then they pull you over. Could have dealt with it, but then you took off.
Oh, I didn't take off, Your Honor.
hold on.
The charges were just filed.
I'm gonna advise you at least.
Yeah, I would.
And not want to say anything.
Yeah, I was.
Felt as you were gonna say something else.
I want to clarify. They got him. So he ran from the traffic stop and they were able to catch up with him and put handcuffs on him. I'm not sure why there was a delay in the case. But my understanding from this police report is at the time of the arrest, he had active warrants. And that was in February of this year. And since then, there was an assault and battery case in Ypsilanti, which has also been filed with an incident date from April of this year. And now we are here, both of those having happened since he's been on probation for the CCW cases, my understanding.
I'll grant the motion, but I'm not gonna give him a PR. I'll make it a 10%.
Thank you, Your Honor.
Round.
Okay, thank you.
If I have to give you a date, we'll set is for a PCC. PCC will be adjourned to August 6th.
I'm on tether for 4 months. I showed up.
You want to keep talking? You want me to change it back?
No, sir. I apologize. I'm not trying.
I mean, I gave you a break because with all that stuff, I shouldn't do it, but I can't give you a PR.
I understand.
All right, I'm done. Thank you.
I'm not trying to talk back. Beth. Load up there.
You know, it
Your Honor, I'm sorry.
showed up every time. Because when you show up every time, you get warrants. That's how we got 3. What? No, I'm not doing anymore.
Oh,
What do you mean?
I gotta go.
Everything is going just fine. I see ghosts. I didn't hear you. Court calls case, People versus Lawrence Ransom.
People.
Joy Gaines, Senior Assistant Public Defender representing Mr. Ransom. Your Honor, I have attempted to reach Mr. Ransom by phone.
Number 4 bus. Never mind.
My-
No, he's not. No, he's not. No. Go ahead. What were you gonna say?
I did attempt to reach him yesterday by phone. I believe his was one of the court dates that was changed. I was unable to reach him. He has been working with and meeting with the 34th District Court in an attempt to resolve this matter with him appearing in a specialty court in Wayne County. So I would ask for an adjournment to get him to court today, please, or a different day.
You're so nice when she asks that. But no. Bench warrant will issue for defendant's failure to appear, but I won't issue it until Friday.
What's the name, Your Honor? I'm sorry.
Thank you.
Pardon?
Mr. Ransom.
Your Honor, just break your knife for. separate matter.
On this one?
No, on a separate matter.
Fine. Now
Thank you, Brad.
I've got to stand up because they're only like this tall.
Yeah, it's true.
Get over the thing.
Oh.
Judge Slay.
August 13th, 2026, 1:30, Judge Slay.
Can I address bond briefly, Your Honor?
Sure.
I did have a chance to talk to Brad Smith and Diana Curry before today. He's been participating in the Dawn Farm Jail program. He has 5 weeks of sobriety as of yesterday. He's doing terrific. He has a place to go. His significant other is here. They've been together for 7 years. She's a professor at University of Michigan. She's got a safe place to go. I would be fine with a scram tether or a home confinement. We do have an application in for felony treatment court. He does need to be screened and assessed, and there's an issue as far as eligibility. But
Professor or
she is, yes. But I wanted to make sure you knew he's got a safe place to go. They have a home together, have had for 7 years. So he's got a safe place to go from here. There is an issue about eligibility, which I've talked to Ms. Feltus about. But they are willing to consider an application, and I would like to see if I can get him out of here. He does have an opportunity to get into Dawn Farm inpatient residential treatment, 90 days. We have talked to the Dawn Farm intake team, his family has, and he had an opportunity to get into the farm as well. So I'm just asking that he be released to even home confinement.
How much time does he have on the Dawn Farm in jail program?
How many weeks have you been going in jail program?
3 weeks into that program right now.
3 weeks?
You're 3 weeks in?
Yes, Your Honor.
I think Your Honor recalls this case from the last time we were here, when he was found with so many different firearms and with the mask and all of the concerning things. I still have all the same public safety concerns that people had before. The treatment, alcohol does definitely seem like it's at the root of this. But the people would ask that if the court is going to release him to the inpatient treatment, which I understand is going to be self-funded from his family or from himself, that he's put on the GPS and SRAM both, so we can keep an eye on him. I'm very concerned with the large number of firearms, if he does get out for his treatment, that we're able to locate him. The other concern is, like Mr. Shand alluded to, whether or not he will ultimately be eligible for felony treatment court with these types of charges remains to be seen. But it does appear that that is what is necessary.
And we're fine with GPS tether and a scram tether, Your Honor. So that's not an issue. We do have pretty good relationships with felony treatment court, and we've been doing this for a while. So I'm hoping that the foundation of the issue, if you look at the video, is he was hammered and he was passed out beside his truck, and he has no memory of what happened. So I'm just hoping that if we address the foundational issues here, that the rest of this is going to be taken care of.
All right, what I will do is, at this juncture, it's gonna be another funny one. I'm gonna deny your request, however, get me an order. You have to get it to me today. Releasing him to inpatient treatment on a GPS and Graham tether.
Okay, perfect.
And those would need to be placed prior to his release from the jail.
Thank you, Your Honor.
All right. And so he'd be released on a PR with those conditions. All right,
To be revoked if he walks away.
walk away.
I'll bring him back.
I know, and I know you will, and I know that, Mr. Shan, so I don't even worry about that, but walk away.
Not for
Lot.
a while.
All right?
All right.
Okay, thank you.
All right. Thank you, Your Honor.
You can make sure that order gets to me today.
I will.
Let's call the case of the People versus Benjamin Spike.
Yes, Your Honor.
Yeah.
Good morning, Your Honor. Assistant Public Defender Alexis serves on behalf of Mr. Spike. Mr. Spike, can you state your name for the judge?
Benjamin Paul Spike.
Thank you,
Your
sir.
Honor.
Your Honor, we'd be requesting an adjournment to continue discussions with the people.
It's just the only thing he's held on.
Yes, Your Honor, if I could briefly address bond.
That wasn't an end. Good.
Your Honor, we would be asking for a personal bond. Mr. Spike is eager to get back out to take care of some of his affairs. He has a friend he can stay with in Adrian, and he does have his dad who provides support for him and transportation.
Why didn't he?
From court? Your Honor, I believe that might have just been an oversight on Mr. Spike.
Oh, okay. Probable cause conference will be adjourned to August 13, 2026, 9 a.m. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor. Thank you.
Court calls case People versus Justin Thomas.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Thomas, who I believe is present via Zoom. Mr. Thomas, can you please state your name for the record?
Justin Thomas.
Got it.
And Your Honor, our AIM division is still working on a mitigation report with Mr. Thomas. We would be requesting an adjournment for that purpose.
Adjourned August 13, 2026, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Adina Self.
Alexander Hermanowski, I'm still here. Alexander Hermanowski with and on behalf, Kadina Self was standing on my right. Please state your name for the record.
Dana Self.
Most I've seen Hermanowski in person. All right, what are you asking for?
Your Honor, at this time, we're asking for a brief adjournment. I was just appointed on this matter yesterday. I haven't had a chance to review the discovery.
And there may be additional discovery, however, not extensive, but a few calls.
A few calls. Okay. I'll adjourn it out to the 13th. How many calls are we talking about?
7 calls that so those calls are all under a minute. However, there's also the call log of the other 6 or incomplete calls that she attempted to do to the victim. So at this point, I'm also going to be asking that her text phone privileges be revoked, given that she's on conditional bond out of 15 for a case for the same victim with no contact order was placed on time of this and is still in place. And she's continuing to violate that court order.
If you've got anything you say, you can say it, but I'm going to do what I do.
Your Honor, you can just go ahead.
All right. I will grant the prosecutor's motion to revoke phone and texting privileges of this defendant while incarcerated. Her bond will continue. All right. Thank you.
I'm sorry, Your Honor. Adjourned to what date?
What did I give? 13th.
Thank you, Your Honor.
You. Court calls case People versus Samantha Kane.
For the people.
Good morning, Your Honor. Roland Sizemore, appearing with and on behalf of Coach approaching the lectern.
Your name, ma'am?
Samantha Kane.
Mr. Sizemore, it's good to see you, sir.
It's good to see you, Judge.
All right, what are we doing?
Well, we just got retained. We're asking the court for 3 or 4 weeks to get discovery and be brought for the hearing.
Hearing no objection, 20th or 27th, which would you prefer?
How about the 20th?
All right, I'll bring matter to August 20th, 2026, 9 a.m. Bond will continue.
We do have one question about bond, Judge.
Why not? Everybody else then. Go ahead.
This is an R&O case. It's the only count charged. However, the police were responding to a call that she made that may or may not have involved a domestic incident. As such, there is a no contact order with her husband and a no go-to order for the residents, even though this isn't charged assaultive crime and he's not a victim. He's present in court. They both would ask the court to remove those 2 conditions from her bond.
That's correct, Ron. That is my understanding of the conditions as well. Victim advocate Roddy did have a chance to speak with Mr. Kane and let him know that generally this court does like to hear from folks about that. So he's prepared to address the court. The court would like to hear from him.
Yes.
If you'd like us to approach, we're happy to do that as well.
Yeah, well, if you could approach,
Thank you.
do it that way. I don't. You say 10 years and 2.
No contact should be lifted.
Okay, you don't have any fear of her at all?
No, sir.
And what's her relation to you?
My wife,
How long you guys been married?
9,
You should be able to spit that out a lot quicker than that.
10 years, sir.
You know, I know what?
Here's,
I just say no because he couldn't get the number of years. Go ahead, I'll give you another shot.
years and 2 weeks.
You say 10 years and 2 weeks.
He did.
So now he's got it like that. All right. Was there a no go to?
Yes, Your Honor.
Okay, on this one, thank you, sir. I'm going to grant the motion for modification of bond, given the nature of the charges and having heard. So I will get us back in here. I will delete no go to, and also I'm just going to delete the no contact. I'm not going to even.
Thank you, Your Honor.
Non-consensual contact. I'm just going to delete them.
Thank you.
Right? Thank you.
Do we wait here for an order or should we go down there for a bond order or will we not get a bond order?
Mark. Won't get one. Because it's him. Yeah. No, he won't get an order. No. You won't get a copy.
No order then?
Yeah, no order, but we'll be removing both of those provisions from lien.
Okay. Thank you, Your Honor.
All right, thank you. Take care. Court calls case, People versus Derek Simpson.
I just felt this with people.
No relation. Okay. Who's the attorney?
Oh, is this his picture?
I know. Is she in the room or is?
Everyone, I don't think.
Because she'd be so small, we wouldn't see.
Sorry, Your Honor. Good morning, Your Honor. Marcia Creech on behalf of Mr. Simpson.
Your name, sir?
Derek Simpson.
Thank you.
We'll be asking the court to set this for exam. Discovery is complete.
People have their witnesses available. Is this the only thing holding him?
I believe so. There may be a misdemeanor issue, but I think this case is driving it.
Would people have their witnesses available the 4th?
Try for that date, Your Honor.
Preliminary examination will be set August 4th, 2026, 9 AM before Judge Washington.
Thank you, Your Honor.
Thank you. Court calls case People versus Keon Wells. This is an in custody.
Actually, I'll just.
Am I out of?
Yes, now we've got Justine.
Okay, so it's gonna slow down.
Brenda, there's some green sheets. They're not mine. I don't know whose they are. Oh, they're Michael Gotti's.
Right, you can never find his.
You're sitting up here.
Oh, the mistake.
Where's everything?
What is it? I thought you got it.
I help.
Keon Wells, are they?
He is back there.
Oh, no, I know. We got a whole bunch of people back there. Your name?
Keon Wells.
Thank you.
Your Honor, we're going to ask this matter be set for preliminary examination. As far as I know, I have all the discovery.
People have their witnesses available the 4th.
We will try for that date, Your Honor. I'm not sure if we've been able to get the videos over to Mr. Goldstein or not. I don't have his appearance in our record, but we can try for the 4th.
All right. Preliminary examination will be set August 4th, 2026, 9 AM before Judge Perry.
Your Honor, I do have a request with regard to bond that's a little unusual. He is on a PR bond with a GPS tether. They will not put a tether on him because he has a hold out of Macomb County.
Yeah.
If you lift the requirement of the GPS tether, then I can get him arraigned on the Macomb County case and get that moving. But they will not even do a Zoom with him as long as he's got that tether requirement.
Who won't do this?
Macomb.
Your Honor, I'm going to object to that request at this time because we have an exam in a week. And if we give a PR and Macomb takes them, then we're losing.
Well, they'll take him just to do the arraignment, Your Honor. I can have him back here by the 4th.
That's not what they've been doing. That's part of the problem. I'm going to deny the request. I'm going to leave the bond in place.
Okay, it's only a week, so okay, fine. That's fine. All right.
Here's me.
Court calls the case People versus Jason Wilson.
Sorry, Your Honor. Rob Jacob on behalf of Mr. Wilson. Your Honor, I was appointed last night on both these matters. I was told he was out, and I was told he was in, then I went to see him. They said he was out, so I have not had a chance to speak with this young man. I'm going to ask for an adjournment unless you have an.
Your name, sir?
Jason Wilson.
All right. I will adjourn these matters to my next date of August 6th.
Okay, thank you.
2026. Bond continue. Thank you.
All right. My name's Bob Kelly. Bob Kelly. I'll be down.
You got to keep moving. I like custodies, and I don't plan on being up here all day.
All right, Your Honor.
Court does call the case People versus Tyrese Pitts. This is
Actually, felt this with people.
David I. Goldstein, bring on behalf of the defendant. I think there are 2 files, Your Honor, on both files.
Yes, you're on both files.
Yes, Your Honor.
All right.
Your Honor, with regard, sorry, Mr. Pitts, state your full name.
Tyrese Pitts. Thank you.
Your Honor, with regard to the older file, I have discovery on. We're prepared to move forward on that one. It was set for exam at one point, but because of the charges, we set it back on the PCC docket. With regard to the new file, Farnwell did email me the discovery last night. It's approximately 800 pages. So I'm going to need a little bit of time to look it over.
That is all correct, Your Honor.
Okay. So what do you want me to, just want me to out the PCCs on both cases?
Yes, Your Honor. May as well keep, although they're separate cases, we may as well together.
Will the 20th be enough time for you or?
Your Honor, actually, the 20th is a bad week for me because I've got a long trial in Lenawee County starting on the 18th. So I was looking at the 11th.
The 11th? Think you get through it? Okay.
Yeah, I will.
Yeah, it would.
I'm sorry. I'm sorry. You're right. So I meant the 13th. I meant the 13th.
13. Okay. Now, my understanding also, there's a co-defendant.
Two.
There are two co-defendants. Who is counsel on those? Do we?
Your Honor, there's a different co-defendant in each case, I believe. Is that correct?
Barnwell is the co-defendant. Counsel, and then
Davon Moore is the co-defendant on the new case.
that's Mr. Kilowolf.
All right. On Moore, are you going to be looking to adjourn your matter? Okay, and if I adjourn your matter, will the 13th work for you? All right, so that's fine. And then on the other matter,
Ms. Barnwell was here.
yeah. All right, Miss, we don't need Miss Barnwell. So Mr. Bernstein is on the other one.
That's my understanding.
You're good with, okay, all right. So I will adjourn both of Mr. Pitt's matter to August 13th, 2026, 9 a.m. Bond will continue.
It wasn't Greenland said her name was police.
All right, thank you.
Thank you, Your Honor.
Court calls the case People versus Marcus Holman.
Fairly done on behalf of the school, Your Honor.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Marcus Holman.
Thank you.
Your Honor, same thing in this case. I was just retained to not have discovery as of yet. Asking you. 13 works for me.
We'll adjourn it out to August 13th, 2026, 9 a.m.
Fine.
Yes.
Currently, before Your Honor, with the city Green case for a misdemeanor domestic violence case, I think the 14B. He is still calling the victims from jail. This case stems from jail calls. After he was arraigned on this case, he continues to call the victim. He has one complete and then 12 attempts to continue calling her. So at this point, I'm going to ask for his phone for the to be revoked given that he cannot follow the no contact order.
What is his current balance set at?
What is, I don't know, Your Honor.
$1,000 cash surety in this case.
All right, I will order that the defendant's phone and texting privileges are hereby ordered revoked this time. I'm also going to revoke the defendant's bond. He can't cooperate, it seems, with the conditions the court has given. So his bond's revoked, phone privileges are also revoked. Thank you. Those case, Donovan Buckner.
Passing those to people.
An assistant public defender, Zach Vinny, with and on behalf of Mr. Buckner, who approaches. Can you please state your name?
Good morning, Your Honor. My name is Donovan Buckner.
Your Honor, we are requesting an adjournment for further negotiations with the people, and then briefly as to bond, we're requesting release to treatment.
Probable cause conference. Is this the only thing holding him?
Yes, Your Honor.
August 13th, 2026, 9 a.m. Any objection to release to treatment on GPS teller?
I don't see a history of failing to appear. I won't object.
I will sign an order upon its presentation.
Thank you, Your Honor.
I want to do that today. Court calls case People versus Christopher Ciccelli.
Michael Gaddy is the public defender on behalf of Kelly, approaching judge. State your name.
Christopher Ciccelli.
Your Honor, we're asking the court to set an exam.
Discovery is complete.
Yes, Judge.
It's the only thing holding him.
Your Honor,
yes, it is the only thing holding him, but I'm informed by the prosecutor that there is a resisting charge from March that has been in the authorization queue and a retail fraud that's in the authorization queue.
If I have their witnesses available the fourth. All right. Preliminary examination will be set August 4th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor. Your Honor, if I could address bond just briefly.
Yes.
Held on a bond.
Yes, he is being held on. Yeah, the bond violation, I believe, is the retail fraud charge.
New retail fraud.
That was, yes. Your Honor, Mr. Kelly is here. We're asking that the court consider a release to treatment if a bed becomes available.
At this time, I'm not over that. I'm good.
Thank you, Your Honor.
Court calls the case of the people versus Warner Ali Thomas.
Assistant Public Defender Dobby Leave on behalf of Mr. Ali Thomas. Oh.
So I'll adjourn as probable cause to August 20th, 2026, 9 a.m. bond.
Take care.
Court calls the case people versus Eddie Duckworth.
Your Honor. Waiting Senior Assistant Public Defender, representing Mr. Duckworth, who's approaching the building.
Your name, sir?
Italy Duckworth.
Thank you.
Your Honor, we are requesting a preliminary examination on the matter.
Discovery is complete.
Your Honor, there is one request and Miss Linda has indicated that she believes that it could be available within for the preliminary exam.
This on the 11th, Christine emailed me last night about possible body work camera, so I believe you can set it for the 11th, have it before that date.
People would have their witnesses available that day. Preliminary examination, August 11th, 2026, 9 a.m. before Judge Barr. Bond will continue.
Thank you. Your Honor, we're going to ask if we could address bond.
Go ahead.
Mr. Duckworth is indicating that he has been employed as a at the same place of employment as a die setter for 3 years. He indicates that at this time they are holding his employment. He has been in full communication with them about this matter, and they are aware of the ongoing challenges between he and his adult child's mother. He indicates that he would return for all future court dates. He has no objection to a no contact order, and also states that he has no objection to a tether if Your Honor wanted to place him on a GPS tether. We are asking that the court consider that so that he can maintain his employment. He does have in total 5 children, and one, as I mentioned, is the adult. He has 2 adult children and 3 young children, one as young as 8.
Wrong.
Trying to put off communication, she changed her number, so you can contact her, you can find the number, keep contacting her, she moved, you would find her when she moved, he would at the gas station she was at, threatened to kill her. Eventually, she had to talk to him about some common things that they have, and when she went to his residence, an argument began, grabbed her by her hair, dragged her to the bed, strangled her, then
That's what we told him.
and then told her to leave, but when she tried to leave, he would block her from the meetings. He then sent her numerous text messages, or at some point sent her text messages saying, bitch, you'll be dead soon, don't nobody give a fuck, bitch, you'll be in an accident soon, you'll be dead soon, I just want you to die horribly. He has other convictions for aggravated stalking from 2008, a 2014 conviction for RNO, a 2021 RNO conviction, and a DD conviction from 2019.
No, this way. Motion for bond reduction is denied. Bond will continue.
Thank you.
Finances paid.
Oh, he's done. Okay, all right. Check. Because then it was ready to keep going. Court does call the case, People versus Kyle Humphreys.
For the people in all three matters.
Ken Madadush on behalf of Mr. Humphreys, also in all three matters. There's green sheets here on the floor.
Who you handed them to?
They're not mine. I have my,
First,
I have my own.
just leaving them everywhere.
I got my own.
Sir, your name.
Oh, Joy, sorry to call you.
Humphreys. Thanks.
Hello, Your Honor.
Hello, what are we
Sir.
doing?
We are going to be waiving Mr. Humphreys' right to preliminary exemption, inviting this over.
In all of these matters?
In all of these matters, yes, Your Honor. And a moment to address one. Your Honor would grant it. He does have to sign this.
So you're waiving your right to a preliminary examination in these cases?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand.
You understand you will not have that hearing in any of these matters and you'll proceed to circuit court for further resolution.
I understand, Your Honor.
People also waive their right.
We do as all three files.
Preliminary examination having been waived, defendant is bound over to circuit court in the case ending in 0839 and the case ending in 0722 on both counts 1 and 2. And on the other matter, bound over also on counts 1 and 2 or following.
Thank you, Your Honor.
You acknowledge receipt of the information,
Yes, we acknowledge this is the information and stand mute. Thank you, Your Honor.
waive the formal reading.
One more reading and stand mute.
Fine, Stan. I'll lead you through the whole thing. Go ahead.
We acknowledge the reading of the charges and stand mute and.
All right. Defendant having waived formal reading, standing mute, court will enter not guilty as to all charges. Pretrial will be set for
11th at 1:30.
August 11, 2026, 1:30. Esteban.
Your Honor, we were going to be asking if Mr. Humphreys could be released into inpatient treatment. We can submit an order for that. He is willing to be put on a GPS tether to track where he is. I don't believe he is a flight risk. That wasn't the problem in the past. He had been doing recovery court. He does have a recovery court hearing in 2 days on the 30th. He's hoping to get back into that, which I'm sure will lead him released to another inpatient treatment. We were going to be asking for that today, Your Honor.
Response.
He's in recovery court on 18 different counts. I would ask that this court, yes, I would ask that, and these cases are violations of his probation in that recovery court. So I'd ask that at this time the court deny defense counsel's request and let the recovery court team assess what, if any, release is appropriate.
That's what I'm going to do. So what I will do is I will deny your request for a bond reduction in these cases. Bond will continue. All right, thank you.
May I approach this with any information?
I just do it. Thank you. Court calls case People versus Alfred Wright.
Office for the people.
So
Good morning, Your Honor. On behalf of Mr. Wright, Attorney Nicholas North, PA 6482.
your name, sir?
Alfred Wright.
Thank you. What are we doing?
Your Honor, we're here for a bond violation hearing. I believe that the issue was that he wasn't charging his tether. Your Honor, the reason for that, I do believe, is because he does have cancer, and he does have treatments to do. I think that the cancer combined with just, him being a little elderly, it does promote some kind of confusion as to what, he's supposed to be doing. Even on the bond violation report that I reviewed, it even said that on one of the days that it came up that he wasn't charging, he was located at the hospital. So they didn't do anything at that time. I believe he was picked up.
Is that the only
from a
reason,
different
counsel, he's in custody at this point?
Well, the other, well, to be at this point, yes, that is the only reason, because he got a personal bond on his other case. But honestly, and to be honest, it's a different case with the exact same facts as this. He has a misdemeanor count for this case out of the city of Ann Arbor. But Judge Garwood gave him a personal bond last week. So I was asking you to give him basically the same bond that he had before.
Any objection from the people?
If I understand correctly, it sounds like he has a new misdemeanor case that he acquired while on bond for this case.
I'm not. No.
I'm not aware of any new misdemeanor.
Here's the problem. The only reason he's in custody on this case, I'm just going to cut to the chase, is because he's at the hospital. He hadn't charged his device.
Right.
I don't think it's anything intentional. And so what I'm going to do is, at this point, I'm not going to find a violation.
He already has a prelim date on the 11th, Judge Garwood, Your Honor.
Not in this case?
Yes, sir.
All right. So this will continue to preliminary examination in person, August 11th, 2026, 9 a.m. before Judge Garwood. All right. And I will reinstate his previous bond.
Thank you so much, Judge.
Thank you.
And Mr. Wright,
Yes.
just make sure to keep your device charged, okay?
Yes, sir.
And one thing, Mr. Wright, remember, you've got court in 15th District Court in 2 days on Thursday, okay?
I thought it was Wednesday.
No, it's Thursday.
Oh,
All right, so just remember to be there, okay?
Oh, my warrant. All right. Thank you.
Thank you, Judge.
Court calls case, People versus Jerome Hutchinson.
Proposals for the people.
Join me, Senior Assistant Public Defender Representative. We are requesting an adjournment in order to get some additional discovery, and we'd also like to discuss bond, if Your Honor would.
Adjourned matter August 13, 2026, 9 a.m. Bond continued. Well, bond, go ahead, it's bond.
Yeah, it's my understanding that there is a holdout of Genesee County for Mr. Hutchinson. And we would like the opportunity to have our paralegal staff to see if we can address that. If that is the case, Mr. Hutchinson is asking that he be allowed to be released to a substance abuse treatment program. It's my understanding that the matter out of Genesee County is also a substance matter for possession of.
Well, I'm not even going to address it until that's matters taken care of as to whether or not he would be released on ours, because obviously he's got some hold elsewhere.
And the bond's denied in that case, Your Honor, so I don't know if we're gonna get it back. Those.
Got it.
All right. Thank you.
So, request for change.
What was the date? I'm sorry.
August
13.
Thank you.
Court calls case People versus Robert Jameson. When you get him up.
Good morning, Your Honor. Assistant Public Defender Alexis Surfs with and on behalf of Mr. Jameson. Can you state your name for the judge?
Robert John Jameson II.
Thank you.
And Your Honor, we'd be requesting an adjournment. We're still waiting to see if he has any approval for recovery court. He has a circuit court date on this upcoming Thursday.
Will the decision be made then, or? Don't know.
I don't know, Your Honor. I just know that this case has been referred along with that circuit court case.
All right, then let me put it out to the 13th. Let's see what happens with that other one. August 13th, 2020.
Thank you.
9 a.m.
Thank you,
Welcome.
Governor.
Court calls the cases of the people versus Roderick Miller.
Matters.
On behalf of Roderick Miller. Please state your name.
Roderick Miller for the court. Good morning.
Good morning, sir.
How are you today?
I'm doing great. How you doing?
I can't tell. You got a whole bunch of people waiting on you.
That happens to me.
Yeah.
All right. What are we doing? I need.
Your Honor, we're asking to adjourn these and hoping for an eventual offer, and I would ask to address bond.
Of course you would. Will the 13th be enough time for you to get that done, or need the 20th? Is he held on anything else?
He's held on two misdemeanors with you, pretrial August 5th.
Got it.
I have,
He also has a bond violation, Your Honor, for a new retail fraud on the date of July the 20th, 2026.
Yes, he does.
In general, Mr. Jones and I have been discussing these cases, and before I send any offer, I'd like to see him become stable, because I think that we had a long time when he was on bench warrant status, but I'm not quite sure which is the course and which is the part. Is it getting out of being stable? Is it staying into being stable? I'm not quite sure. And the bond violation is a concern as well. So sort of leave that to the court.
I'll adjourn this out to the 13th. All right, August 13th, 2026. 10 a.m. And what was your other request, Counsel?
Your Honor, I'm asking the court to consider release patient treatment. Mr. Miller does want to attain the stability that is sought here, and I think that would be a really good way to start off. He does have a very long-term substance abuse issue, which has contributed to him being unhoused. Part of the reason why he hasn't been able to have stability and come to court and take care of all the things else he needs to take care of.
So if right now he's unhoused.
Yes.
Oh, go ahead.
May I speak? If you don't mind.
Go ahead, your attorney's doing a good job.
I'm gonna be quiet then.
Defendants do that, they blow it, but go ahead. Have a shot.
Yeah,
Okay.
absolutely.
Your Honor, he does get mail at Delanis where he stays in the winter. He stays in the Ann Arbor area. Year round, and he works with Kristen, his case manager at Delanis, who I believe I can try and get in contact with if he is sent to treatment. Perhaps while he's at treatment, Kristen and I can work on the housing situation and set him up, because he has completed probation in the past. He expressed to me that he is excited about the prospect of doing probation, so it can motivate him to stay sober and continue the treatment, after he's inpatient. So we ask the court for these considerations to allow him to attain stability and show that he will comply.
I would prefer that you get in touch with his worker, see where all of that's at. And then I certainly will consider a release, but I would agree with the people. He needs to be stabilized in some way, because he's going to just get himself in trouble, come back before me, and then eventually I'm going to get mad and he's going to come out. We're not going to smile at each other.
Like to see him stabilize and then work on an offer, but I'm not sure when that's going to happen.
And if you have housing before you've been.
That's where I was going, Your Honor. Believe it or not, I stay right down the street at 2808 Canterbury. I am able to walk here.
Got it. Okay.
Canterbury is, I believe it's in the Arborland district.
No, I know where it is. All right. Okay. So what I'm gonna do at this point in time, I'm gonna deny the request, give council time to get through to your worker, get me some more information. Let's see how we can structure something for you.
Thank you, Your Honor. Thank
You're
you.
welcome, sir. Good day.
All right.
Thank you.
Court calls case 2 versus Robert Lee Brabs.
As adults, people.
Still here.
It's the Hermanowski show.
Alexander Hermanowski, standing in for Dan Garin, with and on behalf, Robert Brabs. Mr. Brabs, state your name for the record.
Robert Brabs. Do I have no objection to Mr. Hermanowski stepping in? No. All right, go ahead.
Your Honor, at this time, requesting an adjournment of the PCC to August 6th. I believe that it was submitted.
All right. During this matter, August 6, 2026, 9 a.m.
Your Honor.
Court calls case People versus Grant Garcia. It is. Sorry, didn't mean to wake you.
No, I thought
Oh.
I thought it was pronounced Usha, so until that clicked.
Okay.
Yeah. Can I audition on behalf of Mr. Garcia?
I think I actually pronounced it wrong. Sir,
Yeah,
Grand Matthew Duche.
wrong.
yeah, no, every time he comes out, I
Say.
say it wrong. All right, what are we doing?
Your Honor, we were trying to get a resolution, but I believe there's an old case that is getting reauthorized. We were going to be adjourning for that matter.
Is that a felony reauthorization?
It is, Your Honor. I understand it was a case that was up for examination last week. I think the deputy has informed me there was a misunderstanding and that one got dismissed accidentally, so we are reauthorizing it.
Is that gonna then be part of some larger resolution?
Definitely. It also involves some misdemeanor cases, so.
Well, here's what I'm wondering. I don't want him sitting,
He's not sitting on this case, I'll tell you.
not sitting on this case.
He has low cash bonds on this case. Otherwise I would have asked for a bond motion, but
Yeah, I'm sure he would have.
his
Um,
14A1 misdemeanor is what's holding him until the 5th of August.
got it. So, but they're not gonna have everything reauthorized by the 6th. I mean, to set it for the 6th.
I don't believe so.
Here's what I'll do.
It's up to you though, because you have.
Pardon, I know everything's up to you. Why don't
I'm the-
you, why do you just tell me that? What?
You're right.
I know. About time she learned that.
I've been gone too long.
You have. But it brings joy to my heart that you're here.
Oh, thank you, Judge.
Is that good? Okay, so. All right. Why don't I do this? Let me adjourn these matters to the 13th. And then we can he's got matters before me on the 5th, Pittsfield matters. Get to whoever the Buckovich is here. Tell him that we'll look at his bond at that point on those cases.
Definitely. Okay.
All right.
Honor.
Thank you, sir.
Did you?
Court does call the case People versus Darius Joe.
That's the vote to the people.
Good morning again, Your Honor. Assistant Public Defender Daffy Lebo from Mr. Jones, who stands to my right.
Your name? Darius. Oh, all right. What are we doing?
Your Honor, I would like to set this matter for preliminary examination at this time. Additionally, I would like to address bond, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 4th.
We'll try for that day. Thank you.
Preliminary examination will be set August 4th, 2026, 9 a.m. before Judge Perry. As to bond.
Thank you. With regard to bond, Mr. Jones will admit to the bond violation. What he has explained to me is that he was shown a radius that he believed permitted him to leave his home, provided he stayed within that radius. I've explained to him in great detail that home confinement means home confinement, and that means he needs to stay inside his home unless he's been given explicit permission by the court to leave that location. He understands that now. He also has explained to me that he has an upcoming medical appointment relating to a wrist injury from an injury from a shooting a year ago. He's concerned that may deteriorate. Additionally, he does indicate to me that he has a father with some disabilities that he helps, and he does have a family funeral that would be coming up this Friday that he hopes to be able to attend.
I don't need a response, but motion for bond reduction is denied. In this case, his bond will, I think his bond is denied at this point, right?
Yes, Your Honor.
His bond will continue as denied.
Thank you.
Court does call the case people versus Chelsea Morales.
Haley Zed on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Morales, who's approaching the judge. State your name for the record.
Celso Morales.
Simpson.
Yes, sir.
Your Honor, at this time, we'd ask the court to set up him in this manner.
There is a video that it's a video that defendant sent to victims, their shared child of him listening violence, but we do not have that yet, so I'm not sure when we get it from as part of the stalking.
Your Honor, we have explained that to Mr. Morales.
And Mr. Morales doesn't want you to see that before having an exam.
It was described, Your Honor. It said, it was explained to him. It was described in the police report. We have gone over that one.
And I put a request that was yesterday, I not heard that yet, so
So Mr. Morales, you understand your defense counsel hasn't seen any of that?
Yes, Your Honor, I do understand that.
And you want to go forward with a preliminary examination?
I wanted to revisit the bond conditions, if that was to my understanding, that we would revisit bond conditions.
Well, they can ask for but they're doing two things here.
Yes, sir.
You can certainly ask to have the bond addressed, and I'll take a look at what the deal is with the bond, but want preliminary examination set at this point? Without your counsel having all the discovery in front of you and being able to show it to you?
I'm sorry.
That was a question mark.
Yes, Your Honor, I'm sorry. Could you repeat that for me?
Want your preliminary examination set now, so your attorney, my understanding has been told to you, doesn't have the video which is pertinent to the stalking charge, nor the text message that goes along with that video. He hasn't been able to show it to you.
Yes, Your Honor. I thought under the conditions that we would revisit my bond condition right now. I understand what you're saying about the setting the preliminary exam, and I'm not opposed to that because I do not want to hold up the proceedings of the court. I don't want to disrespect the court in any matter. It's
a matter of disrespect. It's a matter of your rights and whether or not you're going to be fully protected. That's all I'm looking at.
Yes, Your Honor. Do you mind if I read this note for you that I prepared?
But no.
I would advise against it. I believe it's about his conditional
The
bond.
conditional release and PR that I wanted to address. Yes, sir. Yes, sir.
When is the video going to be available? Do we know?
Sure, I'm gonna put a request in, it's Pittsfield and they're normally very responsive, so I would hope next week, but I can't speak for certain that it would be.
Your Honor, for what it's worth, I believe there was a transcript of the video in the police report.
It was just a description of
What's on it, but haven't seen it.
I have not, Judge, no.
All right.
It was a rap video, so whatever.
I'll set preliminary examination in this matter for August 11th, 2026, 9 a.m. for Judge Garwood.
Thank you, Your Honor. Your Honor, if I could be heard on bond.
Yes.
Your Honor, Mr. Morales, is, here in court. He does have a rather high, bond in this matter. I don't believe he has any holds. He does live locally with his, significant other. He can reside there. I can give the court that address. I don't believe it's more than a couple miles away from here. Your Honor,
So the individual stalked is not his significant other?
no, Your Honor.
Okay, go ahead.
Allegedly, Your Honor,
Allegedly stalked.
Your Honor, as I said, he does have a place to go. He is under the care of a therapist. He does take medications. He is a recipient of SSD, so he does have income in this matter. He would avail himself of any kind of GPS tether or any other condition that would allow him to both be free in this matter while he's awaiting his exam, but also protect the public in a way that would satisfy any concerns that the court may have, including a tether or any other kind of restrictions. So we'd ask the court to reduce his bond to a personal recognizance.
Your Honor, I would be objecting. We originally requested a $75,000 cash surety, which I would be requesting at this time. This is a case where Ms. Morales pled to 2 stalkings in 2025 with the same victim in Ward State 6. That was worked out as a part of a resolution where they were originally felony charges of stalking. He then, in this case, was messaging the victim directly and then also messaging their young child's tablet, saying, "Are you with your mother?" Then sending a video to the child's tablet of him lip syncing to musical lyrics, beat her ass and kick her out the way, and finally asked, "You're going to die with them." Their child's tablet, after asking for their child's mother with them, while having his fingers in the shape of a gun. So I am concerned that he should not abide by court, pled to stalking and a domestic violence charge in 2025, and is continuing to harass the victim. I don't think he can abide by court orders, and I would have concerns if you were to be released. So at this point, I'm going to be requesting our original request of $75,000 cash surety. I hope that is given this behavior throughout 2025.
Well, Your Honor, look, these are allegations. One thing I didn't hear the prosecutor say, that he's no longer on probation for any of these matters.
But there prior, you said prior domestic violence and stalking?
2 convictions for stalking in 2025, and I have to double check with 482. I didn't see it uploaded in Excel grams, and I find it hard to believe that he's not on probation for those anymore. And then he had also that previous conviction for domestic violence with the same victim. The sheriff child.
The same victim as in this case. So I'm confused. The significant
other,
now somebody else that he lives with
whom he resides, yes, is a different person than the complaining witness in this matter.
But I have like the stalking charge and then 2 other stalkings in a DV against this person. Right?
Can't dispute that.
Anything else?
Nothing further, Judge.
Defendant's motion for reduction of bond is denied. I will grant the people's motion. I find that the assessment of the bond in this case, it's abuse of discretion, and I'll set the bond at $75,000 cash surety.
Thank you, Judge.
Yeah. Court does call the case People versus Marcus Ola.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Ola. Would you please state your name, sir?
Marcus Ference Ola Jr.
You're looking for an adjournment?
That is correct, Your Honor. We are awaiting some additional discovery.
August 13th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Arnold Preston.
Defender on behalf of Mr. Preston is going to be with us momentarily, Judge.
Your name, sir?
Arnold Preston.
All right, what are we doing?
Your Honor, we'd ask for a preliminary exam on this matter.
All discovery is complete.
To the best of my knowledge, Judge.
We'll have their witnesses available the fourth. No week.
For just additional week if possible.
Set preliminary examination August 11th, 2026, 9 a.m. That is for Judge Barr.
Thank you, Your Honor. I don't wish to address bond.
This is a first for everything. Court calls the case People versus Abdul Reynosa Castellon.
Assistant Public Defender Dapi Leba on behalf of Mr. Reynosa Castellan. And Your Honor, Mr. Reynosa Castellan does require an interpreter.
Okay. So when were you going to tell us?
My understanding was that the court was already aware.
We certainly were.
What language?
Spanish. And my apologies.
Have to take him back, go to the end, because I've got a Spanish interpreter coming at the end.
Yes, Your Honor.
Here. Court calls the case People versus Devon Moore.
Pretty Arnold, Chief Lawman. Would you take your name for the record, please?
Dave Moore.
Judge, I think we agreed previously adjourn this PCCs to the 13th.
That's correct.
13th. Probable cause conferences we adjourned to August 13th, 2026, 9 a.m.
Thank you.
Discovery.
Bond continued. Thank you. Court calls case People versus Terrell Stevens.
People.
Sam Bernstein for Mr. Stevens, Your Honor.
I'm trying to.
Yosa, go ahead. Just one second. Yeah, hold it. Can you get out? Go ahead. Go ahead.
Your Honor.
Okay.
Yes, this was, we discussed August 13th, next date.
During the matter, August 13th, 2026, 90.
Thank you, Your Honor.
Thank you.
Oh.
Court does call the case versus Rick Artuso.
I should go with people.
Kelsey Vergils on behalf of Rick Artuso. Is he in custody, Your Honor? Oh,
Yes.
I apologize.
Know that?
I did not know that, Your Honor.
I'm gonna get a bond argument. It's, never mind. Your name, sir?
Rick Artuso.
Thank you.
Your Honor, I would ask for a very brief adjournment so that we can discuss potential waiver with Mr. Artuso.
Probable cause conference will be adjourned to August 6th, 2026, 9 a.m.
Thank you.
No way. Clerk calls the case, people versus Matthew Morrison, aka Esther Murphy.
Chelsea Virgil is with and on behalf of Esther Murphy, formerly known as Matthew Morrison.
Esther Murphy.
You're requesting an adjournment?
I am. Ms. Feltus has indicated she'd like to see some compliance on bond prior to making an offer, so we're asking to adjourn for a plea discussion, and I would ask to address bond if Your Honor would allow.
Yes, go ahead, address bond, I'll give you a date.
Your Honor, I'm asking for a personal bond, potentially with a scram tether if the court sees fit. Ms. Murphy is happy to report she has stable housing now. She is staying with her aunt in Ann Arbor. Her aunt is sober and so is Ms. Murphy, and she would like to stay that way. No prior convictions. She does have some open cases, but those are just orderlies in 15th District Court, which she hopes to take care of. She has previously gone to AA or NA in the past and wants to work on continuing staying sober and having just an environment of stability. Notably, she is unfortunately in the advanced stages of liver disease, and I would argue that the jail can't provide the level of health care that is necessary for her continued survival. She needs exceptionally clean air, water, and food, have her enzymes tested frequently to make sure that she's not at risk of actual death. She is at this time actually having severe pain and is worried that it could get much worse quickly. She has almost died from liver failure twice in the past, extensive history of stays at the U of M hospital. So in order to get the medical care that she needs and to show that she can have the stability that the prosecution would like to see, I'm asking for a personal bond.
Ms. Murphy did fly with her straight tether for about 2 months earlier this year, and then sort of drops off the face of the earth. So people are willing to give her another chance if the court would allow it, with release on his friend's tether with weekly downloads. But should she fail to appear for a download or fail to comply with her bond conditions, we would not agree to any additional releases. Would like to see her fly. I do believe that the officer here is willing to negotiate, is comfortable with the misdemeanor, but now it's me that wants to see a little bit of more compliance. And we lost her from March till July, so it'd be nice to just get her back to compliance.
But prior to that, she was complying.
She was on straight tether, I believe, from about the middle of January to the middle of March and complied. No issues.
Got it. And then what happened?
Your Honor, if I may, Ms. Murphy had housing instability, nowhere to stay, and there was a place available in Lansing for her to stay, which she thought would be a more stable environment and ended up not to be, but she didn't have transportation to get back to Ann Arbor.
That's what I want to know. So after that 2-month period,
There was,
trying to do something else.
yes, she was trying to have stable housing and job and sobriety in Lansing, and she thought that going there, she had the opportunity for that environment. It turned out not to be a good environment, but at that point, she couldn't get herself back here. I think that she would admit to the court that she removed the tether, didn't have it on. However, she did for a long period of time stay sober and is still dedicated to staying sober, partly due to her health, which, as I mentioned, is very essential, but also just to live a better lifestyle.
Came back into custody. How?
I believe she was playing guitar on the street and somebody called in for a wellness check. I don't believe
It
it.
wasn't playing the guitar well, or what? Yeah, I know that was wrong. Was it? No.
I don't think
If I was playing the guitar, somebody.
we may need to consult the body worn camera of that.
Okay.
But I
All right.
think any new charges are expected.
Here's what I'm gonna do. Got an address in Ann Arbor, right? Is that right?
Yes, we can provide that to the court today.
Okay, so what I'm gonna do is I'm going to release her on a personal recognizance with a scram tether. Got to comply with that. Right, and I'm just gonna let you know, especially with the medical that counsel's indicated to me, that if you're not in compliance with that, I figure you don't want to be out and may not want to live. So I'm just gonna take you in and then you'll sit. We understood?
Your Honor.
And then I'll set the date of the August 20th as our next piece.
Thank you.
All right, thank you.
You're
Welcome. Clerk calls the case, Stephen versus David Sharp. What were you yelling at?
Troy Gaines, Senior Assistant Public.
Calm down.
Your Honor, we have a resolution in this matter, and I do have the plea form as well as the advice of rights for Mr. Sharp.
Plea form indicates that the defendant will be pleading guilty to an ad count 2 of disorderly drunk. 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. The defendant is agreed to enter into and participate in mental health treatment court. And there's an agreement of sentence of no dismissal at end, some type of conviction will enter.
That's correct, Your Honor. I would note that count 2 is already charged. It is not added.
Oh, it's not added. It's all right. That's fine. All right, we have sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Warren Sharp.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of disorderly person drunk. Is that correct?
Yes.
It is a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
That charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights in that form.
So what he just said is, do you understand that by pleading guilty, that you're giving up specific rights at trial?
Yes.
You understand you're giving up your right to appeal of it.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily of your own free will? And also because you believe that you are indeed guilty of this offense? Oh, thank you. Just had it in front of me. Go back here. On the date of June 10th, 2026, the location of 810 North 4th Avenue, City of Ann Arbor, Washtenaw County, State of Michigan. Were you at that place, sir?
Wheeler Park, yeah.
Yeah, okay. And so you were out in public.
Yes, I was at a,
And were you intoxicated at that time?
believe so, yes.
All right. Were you acting in a manner because of that intoxication where you caused a public disturbance?
I'm not exact on that, but I'll say yes.
May I ask you a question? May I ask him a question?
Yeah, please.
Were you acting in such a manner that people called law enforcement on you?
I was sitting directly on the table. I may have made a gesture, so.
That's the question I'm asking you, is was law enforcement called to speak with you that day?
Yes,
Okay. And was that because at that time you were intoxicated and behaving in a manner that you would not normally behave?
yes.
All right, sir, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, thank you, Your Honor.
And have I complied with the court?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be August 14th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you.
Thank you.
Right, thank
Thank you,
you.
sir. Court calls case People versus Jason Demansky.
Office for the people.
This is the public defender, Zach Finney, with and on behalf of Mr. Szymanski, who approaches. Please state your name.
Jason Alexander Szymanski.
Thank you.
Your Honor, we're requesting an adjournment. Our AIM team is working with Mr. Szymanski to prepare a report, which we hopefully will be done soon.
13 be enough time for him?
That should be, yes.
August 13th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Armika Thomas.
Assistant Public Defender Zach Finney, with and on behalf of Mr. Thomas, who approaches. State your names.
Armika Thomas.
We would set for exam in this matter, just raise complete to our knowledge.
People have their witnesses available the 4th or need another week. All right. Preliminary examination will be set August 4th, 2026, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond continues. Yeah. Court does call the case People versus Montreal Water.
David I. Goldstein appearing on behalf of the defendant in both matters, Your Honor.
Either right attorneys approaches.
And who? They're not here.
Montreal Walters.
Thank you.
Your Honor, I was just retained on this matter at the end of last week. I have not even received the discovery yet, so I'm asking for an adjournment.
13th.
Adjourned.
Probable cause conference will be adjourned to August 13th, 2026, 9 a.m. Bond continued. All right. Thank you. Well, are the defendants here? You don't know. But they're out here. Court calls the case People versus Eddie Gardner. No idea to counsel.
Good morning, Your Honor. Hannah Burgle appearing on behalf of Mr. Eddie Gardner, who's standing here to my right. Your name for the record,
Eddie
please?
Gardner. I need a P number.
87974.
Got it. Where's the rest of your client's pants?
Apologize, Your Honor.
We'll make sure that doesn't happen again, right?
Definitely.
Thank you. Okay, what are we doing today?
At this time, we're going to request an adjournment of the probable cause conference. We need to complete discovery in this matter.
The defendant's co-defendant was adjourned to August 20th, That'd be a date that I would request.
During this matter, August 20th, 2026, 9 a.m. Bond continues.
Great, thank you. And just for the record, Your Honor, my client is waiving his right to the 21-day time period for
Fill
the
out a green,
preliminary examination. I apologize.
fill out a green sheet,
Not yet. I didn't get.
probably someplace with the rest of his pants. See that filled out so I can sign off on that. Randy.
Will do, Your Honor.
Will also serve as a waiver.
Or I'll give counsel the email address for Joseph Discovery.
All right, thank you.
Thank you, Your Honor.
Your court calls the case People versus Corey Mitchell Lucas.
What was that? I'm talking people you're over there.
State your name. Corey Mitchell Lucas. You know where Mr. Burge is?
I'll grab them. I'll look for
Hey,
it.
you. Okay. You look in the hallway and see if you just see him. Corey, have you had any contact with him? Oh, no. All right, what I'm gonna do is I'm gonna pass him out. I'm gonna have you wait. We're gonna try to get through to him. Done with this case. Oh, you guys. Court calls case People versus Ethan Miller.
Then I'm having people your honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Miller, Your Honor, who's approaching to my right. State your name.
Ethan Miller. Thank you.
Your Honor, in this matter, we'd ask the court to set a preliminary we were going to set a preliminary examination. However, I did speak with Ms. Zenda. It appears that there may be some discovery that's still outstanding in the form.
Still need the entry photos they've done this along with the medical records from this incident. Sending a request to MSP those.
All right. Think we can get. Well, obviously you'd like to see that before.
Yes, Your Honor. I was wondering if the court might consider maybe adjourning this a week so I can see if I can get those.
All right, will that be enough time? All right, I'll adjourn it to August 6th, 2026.
Thank you, Your Honor.
9 a.m.
All right, I'll come visit you.
Hold on. Okay. If this brings down. And this one. I think we only had one. I'm done with you. No, not talking to you anymore. I'm just gonna do this my own way. Okay, that's gonna break. Court calls the case, People versus Douglas Hill.
That's for the people.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Hill.
And Assistant Public Defender Davy Leib on behalf of Mr. Hill in the 16363 matter. Could you state your name, please?
Douglas Hill.
Your Honor, at this time on my case, we have the discovery. If we believe it's all complete, we'll set it for exam.
Likewise, Your Honor.
Well, people have their witnesses available the 4th.
Your honor. I think so.
All right. Set preliminary examination August 4th, 2029 a.m. before Judge Perry on both matters.
That's here.
Yeah, it'll be at this. All right, so you just take the number 4 up. I know the bus now. All right.
Thank you, Your Honor.
See? I learned. I learned something today. We won't be hopping on that, but I learned where it goes. You too. Did you learn that today? Good, you learned something. All right, so now what am I doing? I'm done. No, I'm not talking to you. I'm just gonna call cases. Court calls case, People versus Lawrence Buck.
This is Mr. Burdell's case. I don't know where he is.
Oh.
This facility can't sign it, but he's not in lockup.
He's not in lockup, but it's a facility that needed to sign in.
He's in the County Jail. I don't believe they ever confirmed they read.
I did not.
They're on a different ag stalking RNO case with $300,000 bonds.
Okay. So,
Should pass August 6th. I received the reading this morning for this case, along with parking in the new case. So there's a few.
got it. But do we know how long? You said the bond in Macomb is?
Cash.
Okay, so then what we'll do, so I'll just adjourn it out to August 20th. That was at 26, 9 a.m. That way everything can catch up. So. Liddell, but I thought you said he was in back. Why are you up here? I mean, hello, Miss Saxon. What? Is that what we were doing? Okay. So Burdell's in back.
That is running an exam.
All right, well, do we have an interpreter? Okay, fine. Jeez. Okay, thank you.
Go against it, Vasilios Grios.
Right, Your Honor.
713-422. Somebody sent me what they call the victim's impact statement. And they said they were gonna be in court.
They are.
Who is it?
It's Karen right here.
She shouldn't be, I mean, go ahead and state your appearance.
Sure. Good morning. May it please the court. My name is Matt Savage. I represent Vasilios Grias, who stands to my right.
Your name? Name is Vasilios Grias. She's almost, did you read this statement?
I did, Your Honor.
The only reason I'm saying this is she's almost incriminating herself for filing a false police report. I don't want her to come up here and start saying things on the record. So, I mean.
I agree with you, Your Honor. I felt the same way. If I would have known that was being submitted beforehand, I might have.
I mean, I'm reading this thing and I'm saying, first of all, She's not a victim.
Right.
At least there was no charge filed against Mr. Grius versus her. And then I'm saying she is completely incriminating herself.
Right.
And I don't want to be a party to that. I shouldn't be a party to that. So I'm just gonna pass along here. She doesn't have the right to speak anyway.
Right.
I'm gonna ask you, first of all, but I'm not real excited about Mr. Grius's behavior here, okay? I got an officer in a report saying he punched him in the face. So I'm just telling you, we got a problem here. I don't care if she called and should have, or should have called and called. We don't hit police officers in the face.
Your Honor, I agree, and we had this conversation when we put the plea on the record. You were disappointed then in regards to the.
I'm not disappointed now. I'm uptight about it because we don't have the right. We don't have the right, Mr. Grius. I don't care who you think you are, to hit people for doing their job. We don't have the right to do that. If you don't like what I do, you're going to come up here and punch me? I don't blame you for being quiet. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
I have, Your Honor. There is just one correction, which is the defendant's statement. That statement was actually not submitted by my client. He does desire to allocute. He has the written statement that he's probably going to read to the court because doesn't be public speaking and he's never written a statement before. Judge, the rest of the report is accurate, so there's really no deletions to make to it. I would ask to one, just strike the defendant's statement and actually withdraw that statement that was submitted.
Hey, I guess I'm not following. He didn't write a statement here, did he? All I got is a blank version of offense. Is that what you're talking about?
Well, no, they've stated that there's a statement attached provided by the defendant. He did not provide a statement. He has it with him today.
Okay, I got you. I was confused by that too. Okay.
So that would be the only correction.
Okay.
Your Honor, I have a very short allocution. I know you heard what I stated the last time we were here at pre-trial in regards to me knowing Vasilios for, I think it's almost 18 years now. His daughter's in the courtroom. His son's in the courtroom. I think his son's wife is in the courtroom. His daughter, who's all at the left, her name is Abby. And my daughter and her played hockey together for 18 years. They played Bell Tire temporarily. They competed against each other in college. They play on the same team now. So I've known this family for 18 years. And I'm honored to say that they're friends of mine. You know, Vasilios may have some anger issues, but in terms of actually physically using any aggression towards anybody, I would like to state for the record, Judge, I reviewed the body cam footage 10 times. They were incidental hits. He got tased, and when they were pushing him down and arresting him, there was some flailing done. He never closed his fist and punched anybody intentionally. I have it on my phone if the court would like to review it. I'm letting you know as an officer of the court. You know I've been in front of you since 1994, since you've been on the bench. He did not physically attack anybody. No police officer, no one. And you could read that statement that was submitted. There's limited contact there. I think once you hear his allocution, reading his statement, I think you'll get a better picture of what type of individual he is. I know looking at the report, I've read it, the officer said he was punched. I'm not seeing that. He still committed the crime of resisting arrest. We're not denying that. But his behavior was belligerent and he was just avoiding getting arrested. It's essentially what he was doing. He was holding his.
Let me see that video. Do you have it when they were on the stairs?
Yes, Your Honor. May I approach?
Yeah. Is there a way we can put that on the screen here, Lisa? Do you?
Judge, what I did was I just videotaped it off of my computer.
That's fine.
Tech savvy, but
if he sends it to me by email, I can screen share.
Yeah, let's do that.
Okay.
Then
now you're asking a lot, Judge. Give me 1 second.
no, that's okay. It's going to be Lisa@33court.com. LISA@33court.com. I mean, there've been charges he's had. He's never had anything since 1980 that he was convicted of. I'll grant you that. He had an OWI and 2 domestic that were dismissed.
Correct. It downloading, I apologize.
Take your time.
Lisa,
At 33court.com.
you might want to have her watch it first before she puts it up, just in case, some video of me playing hockey comes up. That would be awful to watch.
Not as bad as my golf game.
I don't have it yet, Judge. I'm still waiting.
Lisa, I apologize.
Let me do this. You go down and talk to her.
Okay.
I'm gonna pass this case. I'll go on to another one. And when you have that all ready to go, Lisa, just let us know if you would, please.
Perfect.
Thanks.
Okay.
Hill, Samuel Lee Hill, 25W727451.
Good morning, Your Honor.
Your name?
Samuel Lee Hill.
Is this Miss?
This is Burns.
I'm gonna need her in here.
John Wayne.
Good morning. Your name?
Morning, Ron. As on behalf of people, PAA 500.
So I just want to make sure I understand. He did everything, but he picked up a new charge for transporting a female for prostitution.
Judge, that is technically violating. I would say I would leave it to your discretion. I do know that it's not an assaultive charge he did. But I did also speak to the witness in the case. The witness was his mother on the case.
The victim.
The victim on the case, yes. It's his mother. She's okay with it being, but she said everything's been brought home, so I will leave that to your discretion.
I just don't feel comfortable. I'm gonna get him a lawyer. What I'm going to do is I'm going to adjourn the review hearing. Let's see here. Let's call in the probation officer here, which is Jessica.
It's just weird. You're going to go forever.
No, I'm gonna have them call.
She came in and talked to me about it as well.
Okay. Lisa, I'm gonna need a date 4 weeks out, which I'm gonna say should be September the 22nd. Let's go until.
Did you say 4 weeks?
Well, what I want
That
to
would-
do is, no, I'm sorry. I want to adjourn it out. I'm gonna extend this probation for 2 months is what I'm gonna do until September 28th. And then I'm gonna set a new review hearing September 22nd.
He's answering probation.
at 8:30. Well, they might. So that's what I'll do. Nobody's there. Okay. That's what I'm gonna do. So I'm gonna give you a new review hearing date. I will get a lawyer for you when you come back here. So Lisa, I want to make sure we appoint him an attorney. When he appears for review hearing date. Sir, if you're convicted of a misdemeanor or a felony of any kind, then I'm sorry, I'm gonna have to enter the conviction and resentence. It doesn't necessarily mean jail. The conviction, I cannot dismiss that case with another charge pending. Okay? So that's what I'm doing. You understand?
No, could you like?
Yeah, one of the main provision was not to violate a law. Sir, can you keep your voice down over there, please? Thank you. One of the provisions was you're not to violate a law. Somebody thinks you violated a law. So I'm gonna adjourn this case pending the outcome of that case to determine whether or not I'm going to enter the conviction on the basis that you violated the law. And I will do that. You can tell whoever's representing you on that case that the judge here is putting this off on the domestic, pending the outcome of the case in Oakland County. Okay? You'll come back on September 22nd at 8:30. I will get a lawyer for you. You can go down the hall, get your notice, and we'll go from there. Any questions? Okay, you're all set. Thank you. Floyd, Cassandra Sierra, Jean Floyd. 26M718-266A and B. Good morning, ma'am. Your name? You're charged with no license and speeding. You have the right to an attorney. If you would like one, I will give you one. Would you like an attorney to represent you? Okay, I'll go ahead and arraign you and then I'll send you to the prosecutor. It is alleged that you did on June the 23 of 26, operate a motor vehicle on I-75 northbound near Woodruff and Brownstown at 11:58 a.m. And they think that you did not have a license. That is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. And then you have a speeding charge here of 1 to 5 over. That would be limited access, 0 points, but it would go on your record. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here today?
Yeah.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yeah.
All right. Yep, you still wish to waive your right to a lawyer.
Yeah.
I'm entering a not guilty plea. I'm setting this, I'm gonna let you go talk to the prosecutor. I'm giving you a $500 personal bond. You didn't show up last time. You need to make sure you show up. You cannot leave the state without the consent of the court or violate a law, and you must appear in court as directed. Do you understand all that?
Yes.
So I'm gonna send you to the prosecutor. He'll bring the file over and you talk to her, see what you can work out, okay? Good luck. People against, Christian Joel Venancio. This is 26I-715-434 FYs, 26B-714-758 FY.
Good morning, Your Honor. Scott Weinberg, P45874 on behalf of Mr. Venancio.
Where is Mr. Venancio?
I think I see his family picture, but I think he's got to put his video on, Judge.
Are you Mr. Venancio?
He's on Zoom, Judge. He just doesn't have his video on yet.
Do you guys see
There
me?
he is.
Your name?
Christian Venancio.
What do you want? You want an adjournment? Is that all I
Your
got to
Honor-
worry about?
That's correct, Judge. Judge, just so you know, this is set for an exam next week. It's specially assigned prosecutor. They're 2 different cases, and my
Where's the
client is being,
prosecutor at?
well, the one I just dealt with is down the hall from you, but Madeline, hold on, Madeline, just gotta remember her last name. Morrow is the
Is she
specially assigned prosecutor, and she's not here. And we have, just so you know, Judge, we have a review with a psychologist for my client to be able to get the report to her. And so we are looking to adjourn the preliminary exam, and set a new PCC to see if we can't resolve this.
Want to make sure that she's available. Call in Ms. Osmaro, please, again. Is that,
It's-
is that?
It's
is that
not,
what you do?
she's not there, Judge. She's not there, but
Well, who wrote
Madeline
this
Morrow.
up?
But the prosecutor that's right down the hall from you, right in the court.
Well, I got
But,
two of them here. I got Ms. Osmaro and I got Ms. Holloway. I don't know who this, I'm assuming.
Judge,
this-
I put him in a breakout room with Miss Esmaro.
Yeah.
It's Miss
okay.
Esmeralda. That's why I talked to you.
Why, so if there's a special prosecutor, why isn't the special prosecutor here? I guess is my question. I can't set dates.
I appreciate
And
that,
then
Judge.
have her tell me I can't do it. I don't
appreciate-
mind adjourning this out for a week or two, but I need to make sure she's available when I set the case. I mean,
I understand, Judge. She did talk to the special prosecutor. Maybe she gave her some dates.
yes, someone. Your name?
People be 8493, and I did well, you know, if I'm standing in for.
I know, but I need these special prosecutors here. How can I set a date when they're not here?
She is okay with any date, and I did call her on the phone, it's Madison Quarles case technically, and when we
As
first.
long as nobody's gonna tell me that I need to adjourn it again. As long as nobody's gonna tell me I need to adjourn it again.
Today,
I'm gonna adjourn it today, and I'm gonna adjourn the PCC for a week, and I'm gonna adjourn the exam for 3 weeks. But but I wanna be clear, if she's gonna tell me I'm not available, I'm gonna end up dismissing the case.
I understand, Your Honor, she did let me know that the only day she could do was 8:10 to 8:15 because she'll be in trial. Is that really still in,
No, that's fine. So she can do it the 18th.
that should be fine.
Do you wanna confirm that with her?
I can give her a call, but she did say that 10 to 15 the days that she could.
That's fine. So go confirm that with her, will you please? So that's what I'll do. Mr. Venancio, you have the right to a probable cause conference within 14 days of the date of the arraignment. Your lawyer's asking for an adjournment. If I adjourn this probable cause conference, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, Your Honor.
You waive that right.
Yes, Your Honor.
Also, if I adjourn the preliminary exam for 3 weeks and I adjourn the probable cause conference for 1 week, since you have the right to a preliminary exam within 7 days of the probable cause conference, that means that preliminary exam would not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, Your Honor.
You waive that right.
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
All right, so here's what I'll do.
Your Honor, before you pick that date, if I can, just because I'm out of town until the 18th, I'm out of the country. Could we just do the next week, the 25th?
Let me make sure she's good the 25th. I wish you would have said something when she was in here.
I tried to, but she said anytime's fine as long as it wasn't the 10th to the 15th because she has a trial that week.
John, just do me a favor. Go tell her the 25th.
Awesome.
So I'm adjourning the probable cause conference to August the 4th at 8:30. And then the preliminary exam, barring there being some unforeseen circumstance, to August the 25th.
That should be fine.
She said that'll be fine?
So that should be.
So that's what I'll do. August 4th at 8:30. Preliminary exam will be August the 25th at 10. No adjournments, okay?
Thank you, Judge.
Anything
Your Honor.
else?
No, Your Honor.
All right. But you're not asking for a competency exam, right?
No, Your Honor.
Good enough. That's what we'll do. Have a good day. Thank you.
Thank you, Judge.
Thank you, Your Honor. You as well.
Wachowski. Where's Wachowski? Jacob Allen Wachowski, 25W700782. Is this somebody, one of these lawyers? Is this one of yours, gentlemen, or not?
He's proper.
Why don't you
No,
have a
Judge.
seat right at the table there? Recalling Vasilios Grias, 26W713422FY. All right, Lisa, I'd like you to play that for me. I'm assuming we're all set. Mr. Savage, your name?
Again, for the record, may I please report, my name is Matt Savage and I represent Vasilios Grias.
Your name again, sir?
Vasilios Grias.
Can you play that for me?
Judge, I still don't have it.
Did you go down and work it out with her?
Yes, I did. I was coming back to tell you that for whatever reason, it's not transferring. I have it just copied on my phone. It's only 20 seconds if you'd like.
Let me see it. Pull it
Yeah,
up.
approach.
Yeah.
Sorry, Judge, I'm so not technical.
That's okay.
It's ridiculous.
Let me see.
Okay, so it'll just play over again. This is like the tail end. So take 1 second.
This is the end of the first.
Yeah. Right. It's gonna start over in 1 second. Trying to start it over, just one. No, I guess for this. This is. Hey. Sure. Yeah, I watched it. Sure. Thank you. Body.
That's all right, Beck.
Which is definitely.
I mean, it's, go ahead.
Okay. Thank you.
All right. We've already started the sentence.
Yeah.
There's no material additions, corrections, or deletions, except for the fact that it says see attached statement, and he didn't give it an attached statement.
That is correct.
He has something he wants to read.
Yes, sir.
Go ahead, sir.
I spent a great deal of time reflecting on event June 6, 2026, on how to express my serious remorse. I take full responsibility for my actions and understand the seriousness of what occurred. I am deeply sorry for the conduct and for the impact that it has on everyone involved. I apologize to the officers that evening after the incidents. They were there to protect and serve. I made your job difficult, dangerous, and the reason I want to apologize again. The experience I've had profound effect on both me and my family. I respectfully ask the court to allow me the opportunity to continue caring for those who depend on me. Help support my elderly mother, whose health is declining, and I play an important role in their lives, my family, and my friends, and my significant other. They rely on me. I'm committed to continue for them to be, and I am committed to being a better role model. On July 27, 2020, my wife passed. Suddenly, unexpectedly, at the age of 58. Losing her was the most painful experience in my life. Loss continues to affect me every day. I do not offer any grief as an excuse for my actions. I have come to realize that emotional pain I carry since her passion has affected me in ways that I fully do not recognize. I now understand that I need professional help to process the grief and become a healthier, better version of myself. I'm fully committed to participating in counseling with other understanding, manage my emotions and anger, and do ensure that the incident like this will never happen again. I do not want this single incident to define my character. Instead, I choose to review it in turning point, an opportunity for accountability, personal growth, meaningful change. And I sincerely apologize to everyone affected by this incident. I accept full responsibility for my actions and am committed to making lasting changes in my life.
Did you write that?
That's what I did.
Well done. Well done. Anything else?
No. Well, just simply asking for to adopt a recommendation. Okay.
You did, it just appears to me that you did swing on the officer. Video's not that clear. You should have never done it. He's got some medical conditions. I don't know why they're recommending a psychiatric evaluation.
Just because he wants counseling. So.
He wants that?
Yeah, he wants it. He's gonna do.
Well, I mean, I want him to go to anger management.
Yes.
That's different than psychiatric evaluation, mental health treatment.
Yeah, I don't think he needs psychiatric evaluation, but to just get individual counseling in addition to anger management, that.
Is there anything that prevents him from doing the court work program?
You are, I know his physical health is not the greatest, but do you think he can handle some physical community service, which would be manual labor, but not too harsh?
Will do anything I have to do.
I think he can handle that. He is on disability because he had a back.
I don't know. He's got some issues.
Yeah, he had a back,
right.
that caused him to be on disability.
I don't want to press it. I feel horrible if something happened. What you did was wrong. I sense that you understand and recognize that. It was well written. I do sense that you have a lot of remorse. You've not had any conviction for 46 years. 15 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No firearms. You don't want you to possess firearms or dangerous weapons. You don't have any? Anger management program with 12-week follow-up. If you want counseling in addition to that, you can get it on your own. No contact with the victims, Cameron Pozlako or Tom Timmis. You cannot write, phone, see, text, email, or communicate with them in any form or fashion. $200 in fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are 5 1/4, screening fees 60 for 585, probation fees are 300 for a total of 885. I think I said 15 months probation. I did say that. I'm also going to order 7 days jail credit, 1 serve 6. I'll let you serve those by way of community service. So 48 hours of community service, and I'm going to give you until, let's see, this is July 28th. I'll give you until September the 30th to complete your 48 hours. You may be eligible for early discharge pursuant to statute. You've done everything and there's no violations within the preceding 90 days in 7.5 months. You can come in here and seek early discharge. If you violate, your probation could be revoked. You could be incarcerated for 1 year, 365 days with credit for any time served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Well, I sense that he's remorseful. That's a good thing. I don't see that a ton. Okay, that's what we'll do. Can you pay this today or does he need time? I suspect he needs some time.
You can pay the $585 to them, then.
Well, it's probation fees too, 300, 885.
Pay them monthly, as he,
You just tell me what he can pay today.
he paid the $585 and finding costs, and then it's better making payments for.
I'll just make it $40 a month then, okay? $585 today, $40 monthly, and I'll start that beginning September 1.
Perfect.
If something happens and you need more time, you call the court, we'll go on Zoom. I'll give you an extension, or you can come into court and I'll be glad to give you an extension, okay? But it has to be on or before the due date, 8:30. Just don't ignore me, all right?
Thank you, Your Honor. Thank you.
I wish you well. Thank you. Good luck. You'll meet with probation before you leave. Thanks, Mr. Savage. Have a great day.
You too.
AMHS 826S 118444. Mr. Levitt, your appearance.
Good morning, Your Honor. Michael Levitt, I'm here on behalf of the defendant.
Sorry, I was looking on Zoom. I thought you were on Zoom. I didn't see you walk in.
No, I just got here. Actually, it was good. It was in person. I had to talk to the officer.
You're fine. Okay, so you're authorized here in this plea on behalf of the company, and you are going to plead responsible to overweight with agreed upon fines and costs of $1,100, true?
That is correct.
To that charge of overweight on behalf of the company, responsible or not responsible?
Response.
Please accept at $1,100 fines and costs paid by August the 28th. People Against Hate TV Carriers LLC 26S 118448. Your name again?
Michael Levitt, 245-336. I represent the defendant, KTB Carrier.
So this is the same thing. You're going to plead responsible to overweight. You're authorized during that plea, and there's agreed upon fines and costs of $5,000. True?
That is correct, Your Honor, and I do have authority on behalf of my client after this.
All right. On behalf of the company, to overweight, responsible or not responsible?
Response.
Please accept at $5,000 paid by August the 28th. You're all set.
Thank you.
Nice
Judge.
to see you, Mr. Levitt,
Nice
as
to meet
always. You take care of yourself.
I will. Thank you.
Thank you. Enjoy the summer. What's left of it. There's a lot of it. What do you guys have out there? You've been sitting there, Mr. Holmberg, and what do you have? Did you talk to the prosecutor?
I did, Your Honor. We have Mr. LaBelle. We're just asking for the exam to be set for next week, as I think you already scheduled at 10:15, and he's here.
File on LaBelle? All right, she's gonna get it together there, and we'll, People Against Jacob Allen Wachowski, 25W700782FY. Come on up here. Your name?
Jacob Crosby.
You've been drinking today, huh?
Not today.
You didn't violate any bond, you didn't violate any sentence probationary terms and conditions, but I don't want you to, we're gonna give you a PBT, okay?
Not sure what it is.
Machine you're gonna go blow into. I'm gonna find out if you've been drinking or not. Okay, you didn't drive here, right? You didn't drive here, right? Who drove you here?
Friend of mine.
Where's your friend?
She had already left.
They already leave. That's always what I get. They drop you off and leave. John, have them administer the PBT and we'll see what else they do. Okay, thank you. All right.
Here's the bell.
All right, People Against, Aaron Raymond LaBelle, 26F703624. This is gonna go to exam,
Yes, Your Honor.
your appearance?
Yes, Your Honor. Edward Holmberg on behalf of the defendant. And Mr.
Where's
LaBelle, say
Mr.
your name?
LaBelle at?
Right here, Aaron Raymond LaBelle.
Your name? Okay,
Here.
so we're gonna go to, I don't know what she wrote here, keep PC.
I think she meant kept exam day because the subpoenas already went out for the police officers.
All right, so preliminary exam will continue next week. Preliminary exam will be August the 4th. And then will be at 10:30 in the morning. Is that right, Lisa?
That's correct.
Okay, so that's what I'll see you next week. Anything else?
That's it, Your Honor. Thank you so much. Have a good day.
Thank you. You too. All right. She's processing those. Just give us a second, guys and ladies.
The informal is ready too, if he hasn't put that up yet.
There's an informal I'm gonna do?
Yes.
I mean, it's actually a hearing?
Well, I don't know. They're on Zoom.
Who's got that informal?
Just the troopers here. I'm not sure if the defendant's in person.
I see. All right. Helene Mel Ghazali. 26D 241826. I like this, the way they wrote this. Come on up here. Your name? This is the fishing license case. They say the family has license dismissed in the interest of justice. Case dismissed. Good luck. People against Ali Nasser. Ali Nasser, 26D 242053. Where's Ali Nasser? There you are. Come on in here, please. Mr. At Nasser, you got to start your video and state your name, please. There you go.
Hello, Your Honor.
Your name?
Ali Nasser.
Says you have a license dismissed in the interest of justice. Case dismissed. You're all set. Banu?
Yep. Thank you so much.
Aditya Banu, 26M688869. Mr. McCandless?
Morning, Your Honor. Glenn McCandless, behalf of Mr. Banu.
Is
Judge,
this really gonna go?
well, probably. I mean, we might work it out beforehand, but you know, the officer might or might not show. I don't know.
Didn't they offer you anything?
They don't offer anything on these truck tickets anymore, Your Honor. And you know, this one here, I think was
I didn't realize. Okay, I see.
improper lane, the third lane for the exit. So there's
I
a
got it.
defense, you know, so.
I got it. All
And
right.
nowadays, I think they're writing them and sometimes they don't appear on these, or they let you know that they're not going to appear on it ahead of time. I don't know. I mean, I don't know what's going to happen. So we just have to set it.
Just gonna set it for hearing next week. At what time, Lisa?
9:30.
At 9:30. Good with you?
What day would that be, Judge? I'm
August
sorry.
the 4th.
August the 4th. Is that in person?
Yeah,
Ooh.
I can make it later. 10:30.
Actually, earlier is probably, but,
You want to make it earlier?
yeah, I think earlier is probably gonna be it. I got
Make it at 8:30. How's that?
8:30 a.m. That's perfect. August 4th.
All right, so this will be in person next week, August 4th,
Okay.
and you're gonna have your client, right?
I should have them on Zoom or live. These guys are out of Canada.
He's out of Canada. I don't
yeah.
mind if he appears by Zoom,
Okay, thank you.
in person, but defendant can appear by Zoom.
Okay, thank you.
All right,
And
see
then-
you next
then-
week. How you
then
doing,
I have
Mr.
another one
McCandless?
from
All right?
Michael. I have another case, Michael Frames, same thing, truck driver.
Yep, I got that one. Michael Frames, 26M 705-795.
Glenn McCandless, to be up, Mr. Frames. Judge, we're asking to set that matter for formal. August
We'll
4th
just
at
adjourn
8:30.
this for a formal. That'll be August the 4th at 8:30.
Okay.
Attorney in person. Where's the defendant from?
He is from Toledo, apparently.
I don't care. He can appear by Zoom if you want. If
Okay.
you want, if he wants to appear here,
Yeah.
I just need you here, okay?
Okay,
You're all
thank you.
set.
Have a good day.
Thank you.
Have a nice day. Nice seeing you.
Bye now. Sherelle Bianca Benson. 26X472-3703. Trooper, or what do I have here? Trooper Bayer. Is he out there?
Yep. He's coming in right now.
Good morning, Trooper. Your name?
Morning, Your Honor. Trooper Buyer.
You're a winner today. The defendant failed to appear. Case, default judgment. Case was scheduled for 9. It's now 9:28. The defendant failed to appear. I think I got another one of yours maybe here. Oh, wait a
I got
minute.
2 today.
We're having video or audio equipment difficulties here. All right, Nicholas Anthony Jones. Did you get that last one, by the way? Did you get the last one? Okay, so I gotta call that one. Wait, one second. Stay right there. Sherelle Bianca Benson, we had recording equipment difficulties, so I'm gonna call this one again and put on record, 26M-723-703. She's not here. Your appearance again, Trooper.
Yes, Your Honor, Trooper Buyer.
I'm gonna go ahead and enter a default judgment here. Defendant failed to appear. Thank you. People against Nicholas Anthony Jones. 26M-724-888, A and B. All right. Your name, Trooper?
Yes, Trooper Buyer.
He doesn't have a very good record at all. Did you see it?
I did. I believe there was 4 prior speeds.
I accept responsibility. I really wish there could be no points.
Well, I can't do that when you drive like a maniac. I'm sorry. You can't do that. I mean, I can't go home and look in the mirror when I start giving out impedings with records like this. I mean, what do you want to do on this, Trooper?
If cutting it down to like a 6 to 10 limited access is something he's interested in, I'm fine with that.
What about the expired plate?
I do have.
As long as he took care of it, I'm fine with that being dismissed.
What, do you have any problem with dismissing that?
I do not.
So if you plead to 80 and a 70, he's going to dismiss the 16 to 20 over. There's 1 point, and this will go on your record, and then he's going to dismiss the expired plate. To that charge, 80 and a 70, responsible or not responsible? You got to slow down. Jeez.
Yes.
All right, so I'll accept the plea 175 and dismiss the expired plate. You can go down the hall and pay on the seating, okay?
Thank you.
Slow down, please. Good luck. Thanks, Trooper. Do you have any more?
That's it, Your Honor. Thank you.
Have a great day.
You too.
Jacob Allen Bukowski, 25W700782.1. I need to get him a lawyer right now, John. Who's our
Graziano.
call him Mr. Graziano.
What's the answer today, Judge?
I got it. Seat right at the table behind him, okay?
I'll go try to find it.
Right there, sir. Snurling, Kenzie Marie Snurling, 23G722104FY.
Morning, Your Honor. Michael Pieknik here on behalf of Ms. Snurling.
OIC is now chief. What does that mean?
We're missing some digital discovery. The prosecutor emailed the officer in charge, but the officer, this is a 2022 incident, and that officer has been promoted to chief of police. So she anticipates.
Okay. All right, I got it. Where is Mr. Snurling in?
Ms. Snurling is on Zoom. Ms. Snurling, will you
Sorry.
unmute?
My apologies. Your name, ma'am?
It's Kenzie Snurling.
So this is what I'll do. Ma'am, your lawyer needs an adjournment so they can get him the materials, so the discovery. So I'm willing to adjourn this PCC for 1 week and then the preliminary exam for 3 weeks. So we would make it August the 4th and August the 18th. Is that good with you, counsel?
What time on the 18th is the exam? I have an exam set at 11 already in a different court.
Right.
Let me look it up really quick, Megan.
Ma'am, if I grant his request to adjourn, the probable cause conference will not take place within 14 days of the date of the arraignment. You have the right to have the probable cause conference within 14 days of the date of the arraignment. Do you waive that right?
Yes.
And if I adjourn the exam until the 18th, that means the preliminary exam will not take place within 7 days of the date of the arraignment. Do you waive that right? The date of the probable cause conference. Do you waive that right?
Yes, sir.
All right. Counsel, what do you want to do on the 18th? I don't really want to adjourn it. I can call them in and do it at 1 for you if you want. What court are you in?
Judge, I'm with Judge Zelnick in 25th District, so Lincoln Park. So
And that's at 11?
That's at 11, sir, yes.
Well, let's do this at 9:30. How's that? Is that okay, Lisa?
Did you say 11?
No, at 9:30 on the 18th.
Oh, you're pretty loaded up on the 18th with informals and pre-formals because you're off on the 11th.
Do you think
Can we
this
do
is
the
gonna
afternoon?
go? Do you think this is gonna go?
I do, Judge, because it's if they're without having to really relitigate. It's from 2022. Her name doesn't appear anywhere in the discovery so far that I've gotten. It's very
Okay. Let's still go with the 9:30 exam. Okay. So that's what
Yes.
we'll do. And I'll get you out of here. You show up at 9:30 and we'll have you here. Okay. So we'll
Thank
see
you,
you
Judge.
next week, first of all, August the 4th at 8:30 and then August 18th at 9:30. Okay. And that'll be in person, obviously, the exam. Jacob Allen Witkowski. Have a good day.
Thank you, Judge.
W7000782. Can you come here with Mr. Witkowski?
Yes, sir, Judge.
If you want time to talk to him, you can. Your name?
John Graziani, attorney on behalf of Jacob Witkowski.
Your name?
Jacob Witkowski.
It looks like he posted a bond for failure to pay fines and costs, right?
I did.
The problem is,
It's not under my,
I'm sorry,
it's not under my name, no.
he smelled about it. He told me he wasn't true. He said he drank less. We gave him a PBT. He's got a .16. I don't know how he got here. I hear this old adage all the time that I got dropped off. So I don't feel comfortable with him leaving here.
Judge, I do want to indicate though, in my brief discussions, with him, he does not have transportation. He's basically, living paycheck to paycheck, if you want to even say that. He's basically a homeless person who was able to find housing, and I certainly doubt that he has means for transportation, so I believe that story.
Well, that might be, but I gotta send him to jail. I'm gonna give him a personal bond. I'll let you tell me why I shouldn't. Listen, just let me finish. I don't feel comfortable with sending somebody out that I don't know has a ride. He's got a .16. So what I'm gonna do, and I'll let you go talk to him if you want. I'll let you argue if you want. But my intention is to give him a personal bond and keep him in jail until his BAC is .02 or less. If you want to go out and talk to him,
May I speak with him, Judge?
yeah,
So you
absolutely.
want it right over here in the hallway?
You just, yeah, whatever.
Okay, Judge, we'll be back.
You're not gonna leave or you're gonna have a big problem.
Hold on, Judge, I can assure you, he's not gonna leave.
Good.
Let's
Floyd. Cassandra Sierra Floyd. 26M718266A. And B. You should have been a lawyer. You should have been a lawyer. You got yourself a good deal here. What's your name? All right, so you're gonna plead to allowing an unlicensed driver to drive and impeding traffic, and they're gonna dismiss the no license charge. And they're going to dismiss the speeding charge, and you're gonna plead to impeding, and neither one of these are going on your record. Is that what you want to do? If you plead to allowing an unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail. So all of those. And if you plead to impeding, that's a 0-point civil infraction. Do you understand that? And then I'm going to dismiss the speeding. All right. Did you sign, read, and understand the advice of rights form here today?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yeah.
And do you still wish to waive your right to a lawyer?
Yeah.
The charge of allowing an unlicensed driver to drive, how do you plead?
I'm sorry,
To
not guilty. I'm sorry.
the charge allowing an unlicensed driver to drive, how do you plead?
Not guilty.
Not guilty? You negotiated with him to plead guilty to this and with the no license to be dismissed, right?
Yes, I'm sorry, sir.
I don't want you to apologize. I want to make sure you understand everything here. Do you understand everything here? Okay,
Yes,
what part don't you understand?
so the speeding and the no licenses being dropped to basically impeding.
And allowing an unlicensed driver to drive.
Right. Yeah, okay, yes, sir, I'm sorry.
And that's not going to get reported.
Yes,
I want to answer any other questions before we move on.
no other questions.
Okay, I'm going to ask you again, in the charge allowing an unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a 2020 Kia that was being operated on June 23 of 26 on I-75 near Woodruff and Brownstown?
Yes.
And at that time, you were operating the vehicle
Yeah,
and you were suspended, or you didn't have a valid license, correct?
my license is restricted. I have driving privileges.
Your license in Michigan's been canceled.
Well, I live in the state of Ohio. I haven't lived in the state of Michigan the last,
You did not have a valid license to operate a motor vehicle in the state of Michigan. Is that true or false?
sure.
Are you on probation or parole?
No.
Anybody force you to plead guilty? Please accept it to the charge impeding traffic, responsible or not responsible.
Responsible.
I'll accept that plea, accept the plea to allow an unlicensed driver to drive, dismiss the speed, dismiss the no license. Why aren't you getting a valid license in these places here, man? You don't have a valid license here. You don't, it sounds like you don't have one in Ohio. You gotta have a valid license before you can drive. You probably drove here too, didn't you?
Sir,
Didn't you?
yes, I did.
Why you drove, what are you doing? You come to court for operating a vehicle without a license and you drive, wait a little bit. I wasn't done talking. You're in court for driving without a license, a valid license, and you drive to court? I shouldn't have asked you that. I don't want you to admit that again. But you can't drive to court to contest or to address a driving without a license and then drive to court without a valid license. Now, ma'am, I don't want to hear any excuses. Can't do that. Can't do that. So I'm going to strongly suggest that you call a mother, sister, brother, husband, boyfriend, friend, whoever, to come and pick you up. Because you're not driving out of this parking lot. Do you understand what I'm telling you?
No.
Do you understand?
Sir, because I have driving privileges, I have paperwork that say I'm allowed to drive on certain days and certain times.
That's in Ohio, maybe. You have a canceled license in Michigan.
Well, I go.
Ma'am,
to Michigan.
Ma'am. I really don't want to argue with you. You don't have a valid license and you're not driving out of the parking lot. If you're so sure you do, then he'll call the police when you drive out of here and they'll decide whether or not they think you have a valid license. But somebody here back on June the 23rd thought you didn't have a valid license. Your record indicates you don't have a valid license. I'm cautioning you. Do not drive out of this parking lot. I don't want to be tough about this, but you can't drive to court on a no license case.
Go back and talk to the court, because I'm confused. I'm so confused.
You can trust me. You don't have a valid license. Okay?
To school, even though my school is in Michigan, I live in Ohio.
No.
Okay, okay, I need to go back to the Toledo court then and speak with them.
You have a canceled license in the state of Michigan. You cannot drive. If you thought you had a valid license, why are you in here pleading guilty to anything? Right? Do not drive out of here. If you drive out of here, you're going to get a ticket. And they're going to bring you back in front of me today. Then you're not going to like what I'm going to do. Okay?
Yes, sir.
All right. See how easy I am to get along with. But you cannot drive without a license. All right, we got each other?
Yes.
Go get a valid license. What else do you want to say? Anything?
No, sir.
All right. Where do you work at?
Work at UTMC, hospital. I'm in school for nursing.
Good.
I go to Chamberlain University in Troy, Michigan, and I stay at Utilio.
Nurses know to but not violate laws, right?
Yes, sir.
$100 fines, 175 costs, 75 victims' rights, $50 justice assessment, 400 or 90 days, and 175 on the impeding. So you owe 575. Can you pay all that?
Yes.
You're gonna call somebody, right?
Yes.
John, you call down there and tell Will to watch him or Brad, and if they see her walk out and you get in a car and drive it, they can call the police.
Okay.
Good luck. Derry Alonzo Emmanuel Mann, 26B712-364FY. All right. Good morning, Ms. Fanning. How are you?
Wonderful, Your Honor. How are you?
Good. Your name?
Attorney Andrew Fanning appearing on behalf of Mr. Mann. Your Honor, I've not had an opportunity to speak to Mr. Mann. I was just appointed, so I probably need a breakout room with him first.
I don't even see him here. Is he here, Lisa?
He is not on Zoom.
He's not here.
Okay, so
I'm gonna
we'll
have
pass
to-
that one. And I don't have a contact telephone number for him or anything.
How come this case is still going on? My Lord. It's from May.
Judge, this is the one where he's been through multiple attorneys. I think Miss Fanning is the fourth.
I don't remember all these. Why? What? He
He's-
keeps firing them? He's gonna do this himself or what?
Yeah, his original attorney was for arraignment only. Then we appointed an attorney. Then he hired Miss Ford. But last week she requested to be removed, and now Miss Fanning's been appointed.
Well, you better try to get a hold of him. Do you have his number?
I don't have a number for him. Can you give that to me, please?
Lisa, can you figure out?
I do
here?
not have a number in the system here.
Yeah, the information that they gave me did not contain a number. It just contained an address. And again, I got it late yesterday. So with that being said, I will do my best. I understand that it's scheduled for exam, the prosecutor for next week. I will be present. I don't know if he'll be present, but I will be present there on next, on the
Show
4th.
warrant for his arrest if he doesn't show up today. And it's gonna be a high
Understood.
bond. And then we're gonna show cause Lisa, the surety company. We're gonna show cause them and let them worry about it. This is 100,000, 10% bond that was set back on May the 29th. And I said it. Oh, this is the one. I remember this one.
I'm just double checking to make sure he's not in custody.
He
Yeah, I don't
can't
see
be.
anything.
And he can't be because he posted the bond.
Well, I thought maybe he had new charges somewhere, but I don't see anything.
Well, Your Honor, I would just ask if we can continue to the exam date.
I'm not gonna make them
Okay.
bring in witnesses when your client he's been firing lawyers left and right. I mean, I guess he knows more than lawyers, and now here's the fourth lawyer and he decides not to show up. I'll wait a little bit for him. What else
Okay.
do you have? You have Hughes.
I have
Let's go on
Mr.
to
Hughes, and we're gonna
Michael-
continue that to exam next week.
Michael Wayne Hughes, 23G 706-009. Come on up here.
Again, for the record, Your Honor, Attorney Andrea Fanning, P 42853. I'm appearing with my client, Mr. Hughes, who's present in the courtroom. Mr. Hughes, state your name for the record.
I'm gonna continue the exam to August the 4th. 10:30 is what we had scheduled, so we'll go on that date, okay?
Okay, thank
All right.
you.
Hang on
You
one
are set,
second.
Mr. Hughes.
Back on the
Thank
other
you.
one, Derry Man, if you want to check back in 15 minutes, sir, you can go down the hall and get your notice, okay? If you want to check back in 15 minutes, but otherwise I'm issuing a warrant. Maybe
Okay,
he's one of
Your
these
Honor,
guys
what
that
I'll
just
do is I'll
slept
just
in
stay on
and
for a little
doesn't think
while.
he has
I'll
to be
just
here
stay
on
on.
time.
Okay.
Okay, good enough. Wachowski, Jacob Allen Wachowski, 25W7007.
Good morning, Judge.
8-2.
John Graziani, on behalf of Jake Housekeeping, my, please identify yourself, sir.
Jake Kowski, you're on.
I got to go back and check on this. It says on July 20, the third party called and wants bond returned to her. Is there anything you want to say? That's my intention.
Judge, he did prank and, that's fine. Again, he'll be let out once it's 0.02, correct?
Correct.
Judge, no problem with that.
All right, I'm going to go ahead and give you a personal bond, Lisa. Of course, you didn't show up on the other one.
Judge, in all fairness, he has declared many warrants.
No, I get it, but I'm trying to figure out. I've got a $350 bond that I'm not releasing, so I want you to keep this. Just make a note. He posted the 3,500 10% bond, and then you're going to have to put on the minimus defendant not to be released, until BAC 0.02 or less. So that should be in about 9 hours, 10 hours. So that's what we'll do. And I'm going to reschedule this for next week, sir. Reset probation violation hearing for August the 4th at 8:30. Okay, is that all right, Lisa? I know I'm piling things on, but I'm going to be gone then.
Can we
So
do a
we'll
little
make-
bit later?
You tell me what time.
10:30.
10:30. Okay, so we'll give you a notice for that. August 4th at 10:30. We're going to send the minimus over and not to be released until BAC 0.02 or less. Okay,
Thank you, Judge.
thank you. Is there,
Everyone in the box, what do you want?
is there a man here? Yeah, he's going to have to go in the box. Todd Dwayne Johnson.
Right, you're on.
This is 26D713033.
Still, 76961. Mr. Johnson stands for rights for research. Record, please.
Todd Johnson.
What does this mean? Adjourn briefly to finalize homework.
So I added that, Your Honor, after the discussion, this is a reasonable offer, and then we had told the APA that he needs to make sure it's gonna work for his license. So he currently has a temporary 625G permit. Upon entering this plea, our understanding is he may temporarily lose that until he's sentenced and could have it restored with sobriety work. For that reason,
Wait a second, slow down. If he pleads guilty today, his license is going to be revoked. Within 45, after 45 days from the time we accept him into the program, he's going to be eligible for a restricted license. So he will have his license revoked. I will have to immobilize that vehicle. If he wasn't the owner though, who's Mary Jane
that's
Johnson?
his wife, Your Honor. That's why we are trying to finalize our homework regarding the vehicle, and he is compliant on bond. We did have a discovery issue as well, so she's now again sent the digital. We expect this to be a resolution, but we're asking for a brief amount of time to make sure he can minimize the exposure he's gonna have to his job. So if he loses that,
Okay, I'm just not understanding why we need to adjourn. That's all. Either way, on the date of the plea, his license is going to be revoked. I can't immobilize his vehicle unless I find out that his wife was in the car with him essentially and let him drive. There you have to show knowledge. What's that?
that's accurate. She was not in the vehicle.
Okay, so I can't immobilize his vehicle. He's going to be revoked. We're going to put him on a bond phase for about 5 or 6 weeks with sobriety court, if that's what he wants to do.
He's just been advised of this offer today, and that's why I want to
Okay,
make sure.
I don't have a problem. I don't have a problem adjourning it. I just don't want there to be a misunderstanding.
Me neither.
And I want you to understand, this is just all these terms that they're right, they're just recommendations. They're not a sentence agreement, correct?
Correct. She's gonna ask for those and we discussed that
And
explicitly.
I do sometimes adopt some of them and sometimes I don't. Sometimes they want me to do batters counseling on a 26 weeks for a push, and I don't condone assaults of any kind, but at any rate, I'll make it August the 4th at 8:30.
Is it possible to push it to the week after the 10th? Just
You're not gonna be here, and I want you to understand something. Everything about sobriety court, every statistical data tells us that the sooner they get in, the more likely they are to be successful. I don't want to just keep pushing it down the road because I'm not going to be here on the 11th, and I don't want to make it the 18th.
Your Honor, we agree completely, and he is fully endorsing sober lifestyle. He is testing 5 times a day through the sober link, so he's had no issues with alcohol, but we want to make sure the underlying treatment and education comes into place. I'm going to advise him that he's going to possibly undertake the alcohol assessment immediately through a referral so that we can have that report considered. Furthermore,
slow down. I'm not following you. I'm gonna order a screening and assessment.
that's very, but he can be proactive as far as addressing some of the underlying concerns. I believe he's also attending meetings, so he is very.
Well, he should be on a sober link device. Have you shown him proof that you've been going to AA twice a week?
Yes, Your Honor.
You've shown your lawyer?
Previous.
I need you to see it today. Have you seen proof that he's been going that he's gone 8 times?
Previously, I don't know, 8 times. I haven't seen it recently. This was.
Show him the AA verification, sir.
Okay, we will address.
Show him now.
I don't have the paper.
Why not? I tell everybody you gotta have the paper with you. Every time you come to court, you have to bring the form with you.
We discussed locations where he's going. I don't believe he's blowing that off, Your Honor, but.
Go get your paper. Where do you live?
Dearborn Heights.
Why'd you come without your paper?
I didn't know I was supposed to.
I tell everybody every time. You gotta bring the form, you have to have the form signed and you have to bring it with you. I'm gonna adjourn it 1 week. That's what I'll do. I don't care if you get a screening or assessment. I'm not gonna rely on that.
Then we won't waste our money.
I wouldn't either. We're gonna do the screening and assessment here, and he needs to evaluate whether or not he wants to do sobriety court. If he does, I'll be glad to take him. If he doesn't, I don't know what to tell him. I mean, I'll adjourn this to August the 4th. What time are we gonna do on this one, Lisa?
9:45.
9:45. But I want you to understand that every statistical data tells us the sooner they get in sobriety court, more likely they are to be successful. So you guys can evaluate it next week. If he pleads, I'll take his plea. We'll get him on a bond phase. We'll set the sentencing to mid-September. We'll put him on, and you can go talk to the probation sobriety court people today, right now. I mean, then he'll understand exactly what it entails. Okay?
Very good, Your Honor.
Thank you very much. Go down the hall, get your notice, and we'll see you back here. Is Derry Man here? I'm calling Derry Man now. What do you got? Thompson? Mr. Kelly, which one? Nicole Ellis. 26M 721-293. Your name?
Roger Cayley, P4811 on behalf of Miss Allison, Your Honor.
All right, so she's gonna plead the double parking. Listen, I'm gonna take this, try not to do double parking. It's kind of a cheesy way to do it. The state gets screwed out of their money. I'm not particularly. To the charge double parking, responsible or not responsible?
Responsible, Judge.
And the seatbelt's dismissed. $65, have her pay by August 4th, okay?
Thank you.
Have a good one. I'm gonna call
You too, buddy.
Mr. Gary Mann here. Gary Alonzo Emmanuel Mann, 26B712-364. Ms. Fanning, your name?
Thank you, Your Honor. If it pleases the court, attorney Andrea Fanning, P42853. I'm appearing on behalf of Mr. Mann. Your Honor,
Go ahead.
I just was gonna say, just for the record, I was just appointed late last night. I do not have a telephone contact number for my client. It's my understanding that, this matter was put over from last week. I cannot explain my client's non-appearance here today.
Ken, I think this is a willful intent to delay adjudication, and I've kind of had it with him. I don't know how many different lawyers he has. If he went to law school and he thinks every lawyer is stupid or what have you, but you're his fourth lawyer. This is a willful intent to delay adjudication. I'm issuing a warrant for his arrest. We're forfeiting the bond. I want to make sure you issue a show cause against the surety company, Lisa. Issue a show cause against the surety company as to why the bond shouldn't be forfeited for defendant's failure to appear. In the meantime, I'm setting 250,000, 10%. If
Thank
he's
you, Your Honor.
cavalier enough to forfeit 100,000, 10%. That's
Thank
it.
you.
Sorry, Ms. Fanning. Have a great day. Thank you.
You as well. Bye-bye.
Lucas John Thompson. Is there something up?
Oh, Judge, I did want to mention, there is a NDS attorney who's here. She has 4 cases that I did just hand over. I did want to mention before you guys went on the record that there's a strike going on, and I know the attorney, she's on Zoom, you can also bring that up.
Yeah, I'll be glad to call those. You
I have her
process
in a
those.
breakout room with one of the defendants.
Lucas John Thompson, 26S576534 A and B. What are we doing on this one? So he's going to plead on file A. How you doing, Mr. Thompson?
Good, how are you?
Your name?
Lucas Thompson.
So he's